such joy to be here today. I feel like all of us that have been involved with CLP at some point or time or the other, when we take the mic, talk about the history of CLP, our association with India, and I was just going to make a joke about how this was a panel, like a Harvard panel. And then, of course, like our last commentator reminded me that it wasn't a panel after all. And that with the Oxford BCL, we have like an important introduction to a different kind of global legal education that I was going to privilege otherwise. I'm Sweta Balakrishnan. I'm a research fellow at New York University in Abu Dhabi, but I'm also an American Bar Foundation fellow where I do a lot of work on legal education and the globalization of the legal profession. But I'm not here in either of those capacities, right? I'm here as a longtime fan and member of this awesome community of Lee scholars. I was one of the first postdocs at the Harvard CLP. It was PLP then, and I just keep calling it PLP. Then you graduated and I graduated. But that was 10 years ago. Like, I feel like I still remember the first conversation we had about Harvard in India, what it meant to think about the global legal education project, what it meant to have the global professional project. And these were conversations that were a big part of my global legal education, right? So I'm here as not just a long-term fan of the community, but also as an affiliated fellow. Okay, this never happens. I'm never too tall for the mic, so this is so awesome. For those of you that were in the presentations yesterday, you might have noticed there were multiple comments about how global law schools have not thought about India seriously, right? So there was a lot of comments on, when I was in law school, India was this question mark, or when I was in law school, no one cared about India. That was not my experience. I went to Harvard more than 10 years ago, and my LLM class, the biggest block of international students were Indians. So the largest number of of students from one country were all from India, and a lot of them were from elite law schools, right? And every year since then, there's been an increasing supply of students in American law schools, and it's hard not to take India seriously anymore. So one of the great things that the GLEE project has done is that it's reshaped that focus on global legal education and made India the center, and it's such an honor to be here and think through these things, not just from the perspective of American law school audiences, which is often my primary audience, but also to rethink it from where it started, which is what is globalization doing to the Indian legal education sector, right? One of the great things about this project, and I have a lot of great things about this project that I can keep saying, but the great thing about this is that how this project is a bottom-up project, right? So it didn't start with a set of questions that everybody was answering in one way. It started off as there's a bunch of scholars that do really cool work on this, and how do we take all that experience and build up from it? I mean, ethnographers like me call it a grounded theory approach. How do we take a bunch of really cool empirical data and build theory upwards from it? And so what we're going to have today is a set of papers that all are uniquely empirical and important in their own right, but speak to each other in ways that I hope you guys will find really amazing and exciting, because I read the book over and over. I reference it nonstop, so you should buy multiple books, but most importantly, you should read the book and think about how it changes the own conversations you're having about global legal profession and education. We're going to start, I think we're going to start in the same order that the panelists are sitting. The first two papers, so Nick Robinson and Vic Khanna, both have papers that talk about this important connection between the corporate law, the rise of the elite corporate law sector and legal education, and what that interdependence looks like from two very different perspectives. So Nick will present his paper with Jonathan Gingrich on the impact of elite law firms on legal education itself. So what are the new kinds of courses that are being had? What kind of internal models of legal education have changed, shaping the assumptions of the market that they have? And Vic Khanna's paper with his colleagues actually takes that one step further and thinks about how legal recruitment, the anatomy of legal recruitment actually shapes what we think of as legal education, right? So it's this recursive relationship between the actor that's presenting legal education and the market that's receiving it. And both those papers are in deep conversation with each other, and I realized earlier today that Vic and Nick are constantly in talk with each other. It's great. The second set of paper that unfortunately we don't have Shamnath Bashir here, but I want to make a slight comment. For those of you that are here that have the book in your hand, and if you're at the end of the panel, I really urge you to crack that open to look at Shamnath's chapter, because one of the really important things that came out of the conversations yesterday, and it's a conversation we've been having at Glee, is how does this impact inequality within the profession, right? And so Shamnat's paper, he writes with colleagues about how all these elite law schools are actually setting up an institution that's inherently unequal in some way. So no matter how good and egalitarian and progressive it looks, it still is unequal in other ways, and what do we actually do to like regroup that? As many of you know, Professor Bashir's organization, IDEA, that I'm very glad to be part of as part of the Board of Trustees, thinks about sustainable inclusivity within legal education, right? So I know a lot of you are law students here, and one way in which I urge you to think about as you hear these comments and questions is what this does for your own experience within the legal education model, what it does for equality and your experience in terms of engaging with an institution that, whether you like it or not, is pretty elitist, right? And so the democratization of legal education is a question that I hope you keep in the back of your head as you listen to these papers and comments. And then our third paper, which is another great chapter from the book, is Vice Chancellor Raj Kumar's paper on experiments in legal education. So I know everyone spoke about the 2012 visit to Delhi, but actually few of us were here at the 2009 visit to Delhi when Raj organized this amazing symposium on legal education and globalization in legal education. And a lot of those questions we asked then in what was, the starting inaugural session of Jindal Global Law School are relevant today, right? So who are the actors? What is the kinds of ways in which the law school model has helped, and how has the law school model led down legal education? And I hope we bring some of that up in the discussion. Then we have three commentators. We have, unfortunately, Professor Ranveer Singh couldn't be here with us because he has an open panel that he had to be at. But we have three amazing market-centric approaches to legal education. So we have, we're going to start with Pallav Shukla, who's a senior associate at Tri-Legal, Tanya Agarwal, who's a partner at S&R and Associates, and Anuj Berry, who's a partner at the Shardul Amarchand Bangladesh in Delhi. And the reason we have three amazing panelists that are going to sort of respond to these papers is, as academics, we have these echo chambers where we're constantly talking to each other and citing each other, and I'm so glad this is so. But one of the great things about a showcase like this is that we get to be in conversation with the people who actually have to live through things that we write about and think are really important. So we're really looking forward to that conversation with the markets that we write about, with the institutions that we hope to be representing when we're talking about this. And so we're really looking forward to those comments. I'm going to be a really strict moderator, so when you get the Shweta glare, you guys know that you have to stop talking. Because one of the great things about this is that we have an amazing audience, and I'm hoping to have questions from the audience, hoping to have a conversation with the audience. We'll do about 8 minutes each for each of the papers. Does that sound good to the three of you? I mean, it's too late. You're getting 8 minutes each. You don't get 8 minutes each. And then we'll have a conversation with the commentators, and then we want to open it out to all of you. So put your hands up, introduce yourself, and please ask questions, right? This is only going to work if you feel as engaged about the project as we feel about you. So I really invite that part of the conversation. With that, we start with next paper.
Thank you so much, Shweta. It's great to be here, to be back in India. I've lived many years here, and it's always wonderful to be back in Delhi, where I lived, and in India. And then thanks, of course, to David, to CLB, to Vic. The Center on the Legal Profession has been very important for me professionally, and it's great to be back amongst friends and mentors. Today I'm discussing a chapter of this book that I wrote with Jonathan Gingrich, who unfortunately can't be here today. But it's as much his chapter as my chapter. So we look at the effect of the rise of the corporate sector on elite legal education in India. I just want to make highlight three takeaways from this chapter. So the first is the usefulness of a demand-side economics prism. This has been kind of a grand narrative over the last day for the book overall, of that demand-side economics is a useful prism for understanding changes in the legal profession, but also in legal education itself. So there's no question that particularly elite legal education in India is vastly different than it was 30 years ago. You used to have under-resourced schools where a lot of the students who went really didn't have other options. The old joke was you just didn't get into medical school or engineering school, or if you went, it was because you had connections to the legal fraternity already. And as we heard yesterday, now this is a first choice option for many students across the country. And our central reason for this change is because of the demand created by the corporate legal sector. Importantly, the corporate legal sector, the story really isn't that it's making specific demands on legal education itself, in the sense that corporate law firms aren't going to regulators and saying change legal education regulation in this way, or they're not endowing a bunch of professorships, although they endow occasional professorships, so it's not like they're investing huge amounts of money into the law itself. Instead, I think the big change that we're seeing here is that the promise of these good-paying, prestigious jobs that are viewed as attainable through meritocratic effort is driving students into legal education and is creating the demand for a new type of lawyer. So a lawyer who's skilled in research, in writing, has communication skills, and has skills in certain areas of the law. And so this, we argue in the chapter, has changed who applies to law school. So you have more educated and more affluent students, more talented students, how they pick law schools, so they're less interested in just going to the law school in their city, but into feeder law schools that go into these law firms. How much they're willing to pay to go to law school. So you see a large increase in fees, which then gives law schools a lot more resources to offer a different kind of legal education. You have schools, some begrudgingly, some quite willingly, offering a more corporate-oriented law school experiences with classes in corporate law and other topics. You have students reshaping their own legal education experience through internships and other activities that they think will polish their CV in a certain way for the corporate law firm sector. So you see this really demand-driven market story as changing legal education, as opposed to what you could imagine is like a regulatory story or a central planning story or a social movement story, right? So this has been very central. Second, and I think this is particularly true coming from the United States, one of the things that's striking about legal education in India is its heterogeneity, right? In the US, there's a lot more homogeneity within a legal education. So what do I mean by this? So of course there's the national law schools. This was a break with the past. You all know this story. The 5-year standalone law school designed initially to train litigators for the bar. However, because of the focus in the national law schools on writing, on multidisciplinarity, attracting students through a highly competitive exam and getting very talented students, it became this accidental corporate success, right? And so we see that model in legal education. But we also have what we call the legacy law schools, right, that are still very much there, like Delhi Law Faculty, Government Law College, that have not been entirely supplanted in this story, even if the corporate law firms don't directly recruit as actively there. And in truth, many law firm founders came from these schools themselves. And there you see 3-year programs, you see 5-year programs. Schools like Government Law College really emphasize things like externships. So very different kinds of models of legal education going on. Then you have the private law schools. So schools like Jindal, who have broad missions, but as part of that mission is more explicitly producing lawyers who can serve this corporate law sector. These schools have more resources, they have more intentional tie-ups globally and with law firms, both domestically and internationally. And so you see a lot of heterogeneity in a legal education, which I think, and maybe we can get into this in discussion, raises questions about, A, will this heterogeneity continue? Will we see a drive towards a more homogeneous legal education landscape? And whether this heterogeneity is a successful model, either in producing corporate lawyers or producing the kinds of lawyers that are needed for the country. So there's many kinds of lawyers that are needed for the country, so maybe heterogeneity is a good thing. So this will be successful. On the other hand, maybe the reason we keep getting different models of legal education is the last model is viewed as being exhausted or failed, and you keep on moving Third and last point. And I think this is a tension in legal education everywhere, but it's particularly true in India, which is between the needs of the corporate sector and the needs of the country, the profession, and of the individuals going to law school themselves. So we've heard this recurring and common complaint that this refocusing on the corporate sector of legal education comes at the cost of generating talented lawyers for other goals, such as litigation, general practice, serving the poor, government. Right? I'll just leave that out. I'm not going to take a stand on that, but I'll leave that out there. For the profession, there's a criticism that this more targeted training can lead to a fracturing of the bar. There's less of a sense of occupational and professional consciousness of cohesiveness. And this idea that arguably the law itself, and unique to the law itself, should be taught as a larger cohesive whole that lawyers engage in. So, for example, if we spent all of our time training doctors to just treat the pancreas because the pancreas pays the most money, we would think that that's a loss not just for the human body, but for the profession more generally. And then importantly, this corporate focus can be potentially a loss for students. So there's a danger of putting students on this narrow path where not only should you be able to explore other areas of law in law school, but there's this danger that, particularly as fees keep increasing, and we see this very much in the United States, and I don't think the United States is a very good model for this. Fees keep increasing with the promise of high-paid jobs, but those high-paid jobs will not materialize for everybody. Students are increasingly getting into debt, so even if they don't want to take the high-paid job, they have to take the high-paid job. And they might take it because they're in debt, or just because there's a reorientation of prestige at these institutions. And so I'll end with that. I'll just end with one last question as I get the Shweta glare. And that is, question is, certainly legal education has been reshaped by the rise of the corporate law firm sector, but it's unclear whether that legal education is actually meeting the needs of the corporate sector. So it's transformed it, but is it meeting those needs? And what is that perspective like, particularly from law firms and the corporate sector? So I'll end there.
Thank you.
Thank you everyone for coming this morning. It's wonderful to see so many of you here on a wonderful sunny day here in New Delhi. So I'm going to present a paper about the legal recruitment process into law firms in India. My co-authors are Aditya Singh and Jonathan Gingrich, both of whom cannot be here today. Aditya has a very poor excuse. He's getting married tomorrow. And Jonathan has an even poorer excuse, which is he's attending the wedding. So due to their tardiness and laziness, I'm here to present the paper instead. I will be very brief in my commentary because I just saw Shweta give Nick the death stare, and I'm actually quite scared. So I'm going to make 3 points in my comments today. The first thing I want to sort of highlight is the fact that changes in how law firm recruitment occurs in India reflect not just the demand for corporate lawyers, but the supply of how that process works to get them into the law firms. And I'm going to describe that as being a kind of a jugaad that I hopefully hope to use to elucidate some things about India's legal profession. The second thing I want to highlight is how that jugaad actually worked at the institutional fine-grained level. That is, how did the students who designed the recruitment process, and yes, it is the students who designed the recruitment process, what did they do to address the kinds of concerns one might expect to see in a recruitment process that's run by students? That is, we're going to see the nimbleness and the agility of jugaad at work. And the third thing I want to highlight is how that jugaad, unlike most other jugaads in India, didn't just fall apart once the process had achieved its desired end. Instead, people in the system continually adjusted it until it actually formed the basis for the now growing recruitment practices within the law firms themselves. So this is actually a good story about jugaad in the sense that you see nimbleness and agility being important to the formation of the more structured, formal recruitment processes within Indian law firms and other legal employers. Okay, so let me start with the very beginning. Many of you already know what the recruitment process was for Indian lawyers prior to liberalization. You were looking primarily at going into litigation practice, which was an ad hoc process of junioring, essentially. What determined who would hire you as a junior was pretty much anything under the sun, and maybe everything under the sun. However, once liberalization and globalization began to hit the Indian environment, you saw a demand for corporate legal services that both Nick and others have highlighted in their presentations today and yesterday. How do you actually then get law students to join law firms? How do they sort? That is, how do the law firms hire the students they want from which universities and so forth? Amazingly, in India, at the time liberalization came, there was no actual recruitment process. That's not surprising, because prior to this, the recruitment process was ad hoc. People just decided individually who they wanted as their junior. Now you have law firms that were increasing in scale that needed to find some structure in place to start hiring people in larger numbers. And the problem they faced was they didn't have one. Worse yet, law firms didn't really have any people that were in the place to actually select and recruit students. Law schools, of course, didn't have anybody either because they didn't do it in the past. It was all ad hoc. So you had something of a gap. Nobody at the law firms could actually help you select and sort students, and nobody at the law schools was willing to do that either. In this gap, the students themselves produced their recruitment process. They created recruitment committee cells, as many of you probably know, or internship committee cells, that basically served to help law firms sort through who would be the students they would hire, or at least to help rank them in ways that would make that process more efficient. Now, one of the most amazing things, of course, about this is you're allowing the students to structure how they get hired. That sounds a little bit like letting the inmates run the asylum. Now, of course, letting the inmates run the asylum is bad if you think the inmates don't know what they're doing. But if the inmates do know what they're doing, then maybe it's not such a bad thing. And it turns out that the students at the Indian law schools actually did seem to know what they were doing. Perhaps they were very motivated, but it turns out that they actually started policing the structure of recruitment in a way that only professional recruitment agencies actually do. Let me give you a few examples. So, for example, one of the things you'd be worried about in the recruitment process would be someone favoring themselves. That would be the most obvious thing. So how did the students do this? Well, what they did was they made sure that the only people who staffed the recruitment committees were those who had already secured employment, or those that were planning not to immediately start working. For example, those who might go into an LLM or something like that. So no fourth-year students were actually allowed to sit on recruitment committees. It had to be fifth-year students and those who had already committed to pursuing an LLM abroad. This made it easier for them not to be worried about these students preferring themselves because they weren't actually part of the process. But of course, that raises the question, why would the fifth-year students and the LLMs actually care about their classmates, their juniors, getting placed? After all, normally you worry about your seniors, not your juniors, right? Well, it turns out the students had a very, shall we say, enlightened view of their professional paths. When we interviewed a number of the students who had served on recruitment committees, and even those that are currently on recruitment committees, we got a couple of things we heard over and over again, which is they all understood the value of having a network. And it benefited them, they thought, that if their juniors were well placed, and if many people from their law school were well placed, that would benefit them professionally as they moved forward. In other words, that if we're part of the same network, if we're looking for a job, if we're looking for promotions, if we're looking for business, someone who was part of our structure, someone who was our junior, might actually be very, very helpful and willing to help us. Now that strikes me as being an enlightened vision of self-interest that you don't typically see of someone who's 22 years old on average. That holds a tremendous amount of promise for where the legal profession is going in India. In a lot of other contexts, we saw them adjust the recruitment process so that they obtained full placements without actually allowing the people running the system to determine where folks went. So for example, if you got an offer through the recruitment process, you were expected, at least initially, to immediately accept it. I think sometimes you were given 1 hour. That doesn't seem like a tremendous amount of time to search for other offers, I suspect, but the idea was by having people quickly take offers, you had full placement occurring at pretty much a fast clip. That was quite stunning. But as we started seeing the legal sector, the corporate legal sector grow, law firms got more and more interested in actually having more of an active say in who they recruited. So now you see law firms beginning to actually invest in placement and recruitment offices within their four corners. And same with law schools. In fact, Jindal, as Raj will probably tell you, has one of the most advanced recruitment processes or placement services we see in law schools in India. What's amazing is when you look at the hiring offices within law firms and the placement offices within law schools, they actually use a lot of the same techniques that the recruitment committees used in their little jugaad to get their students placed. They try to align the incentives of the people doing the recruitment so that they also benefit from the process of having the full placement by, for example, giving them rewards for placing their students more fully. And the law firms also try to do this by incentivizing the people inside their recruitment office by getting them people who actually stay and produce value for the company. Now, part of this, as Shrit is about to give me the death stare, is that I'd like to highlight for all of you the fact that the jugaad that kept adjusting with nimbleness and agility actually created the basic architecture for what we saw coming after that. That is, the law placement cells inside law schools and the hiring departments within law firms. Amazingly, right now in India, all three still persist in varying degrees. That is, you have law school placement cells inside some schools, some large law firms are doing hiring, and of course, the recruitment committees continue operating with a lot of gusto. That doesn't entirely surprise me. India's legal profession is still undergoing quite a lot of churn, so we're seeing a lot of different flowers blooming at the same time. What is fascinating is that they all share very similar structures, suggesting that the jugaad that led to the structure of the recruitment cells has been important in structuring the underlying recruitment process in India. And I'll underline for you why that's important. When you think about how people are placed into the profession, you're talking about how the profession is replenishing itself and recreating itself. So in terms of how the profession develops into the future, how you're hiring into it has a significant impact on what the future looks like. And with that, I'll hand the chair over to the future.
All right, good morning to all of you. Thank you very much, David, for having me part of the book and also indeed the panel discussion. Both yesterday and today we've had an opportunity to reflect about the book. My chapter in the book is about the story of Jindal Global Law School and also in relation to the journey that we have undertaken in relation to building a new law school in India with a very modest beginning. But before I talk about the law school itself, let me first, take you back to my early days of studies in a place called Chennai. This also gives you a picture or potentially the context of legal education evolution. Some of the students here may not fully understand and appreciate the journey that legal education in India has traveled. In the early 90s, when I was aspiring to actually go to law school, on a particular day when I decided to go to law school, when it was publicly known, nearly 20 of my relatives turned up at my home very early in the morning. And we were in a very small house, a very middle-class family. And me and my brother were sitting inside, and my parents were surrounded by these 20 relatives. And for the first 20 minutes, there was absolute silence. And then somebody asked, "What happened to Raj? He was a good student." And then the second person asked, "I know he was not good enough to become a doctor or an engineer, but I thought he will at least become a chartered accountant." And the third person said, "These are very difficult times for you as a family, and we are with you." It took many years till I got the Rhodes Scholarship, where the Hindu reported that I got some respectability among my relatives. Of course, I told the story to my friends in the US, and they told me a very interesting situation in the US, which will emerge in the future, where in a future context, an Indian American will become the US president. And at the swearing-in ceremony where the Chief Justice of the US Supreme Court will administer the oath of office, adjacent to that Chief Justice will be this mother of this president-elect, who will nudge the Chief Justice and tell the Chief Justice, his brother is a doctor. This evolution of recognition of legal education and legal profession from its very modest beginnings to what it is today, when generations of bright young high school kids aspiring to enter into law, is a significant transformation which clearly owes it to the establishment of the National Law Schools in the year 1987. We are 30 years since the establishment of the National Law School, and it's an opportune time for us to reflect about this journey. Of course, it is also important to recognize that it will be a mistake and a futile exercise to look at the law schools in India without consciously addressing the challenge of universities in India, because after all, law schools cannot exist in isolation. At least in India, all law schools are part of a university, either directly or affiliated to. The universities can only give the degree, the law schools cannot give the degree, and hence it becomes important to look at the university environment itself. While I will talk a little bit about the Global Law School towards the latter part of my presentation, I just want to mention for the benefit of the audience that at the dawn of Indian independence, we had 20 universities in the year 1947. In 2017, today we have 850 universities in the country. We have 5,000 plus business schools, and Justice Chandrachud mentioned yesterday that about 1,300 plus law schools. Actually, there are 1,550 law schools today, and that was a count in the morning. I don't know what has happened in the last several hours. The expansion and the evolution and establishment of law schools across the country has been in an extraordinary pace, and most of it is not necessarily good for the country itself. In fact, in a couple of years, during 2012 to 14, nearly 2 to 3 years saw the establishment of 400 new law schools in India, and that is the expansion that has taken place, and unfortunately that has led to a significant level of mediocrity, deeply institutionalized and embedded in our institutions. Even the growth and evolution of National Law School since 1987, when the National Law School Bangalore was established, it took a decade to establish the next National Law School, but then in the last 2 decades, we have had today 22 national law schools, and the state of Maharashtra alone has 3 national law schools, and almost every state has a national law school. It has not been expanding in the pace in which McDonald's is established, but nevertheless, it's pretty close in terms of the eagerness and desire to build a national law school in every state, and one of the states has set a new record with 3 schools in it. So in a way, the big challenge of the evolution of legal education has been that there has been systemic neglect and institutionalized indifference to the ability of institutions to promote high quality legal education. I dare say even the established National Law School from its founding onwards did not focus on the effort to build quality and excellence deeply embedded. The focus has always been to be able to attract the best students, and somehow having the best students in a classroom, something will happen in which students will probably educate themselves, peer group learning and other forms of inspiration can actually bring them to acquire that knowledge. Fundamentally, this has been the problem of most of our institutions, and the problem is deeply embedded in the IITs and IIMs as our premier institutions in engineering and management education, and it is also translated into our legal education in the national law schools. Today, of course, this crisis has led to an existential crisis in universities. The 47 central universities in India has the faculty positions lying vacant of over 45%. My own alma mater, Delhi University, has 45% faculty positions lying vacant, unfilled for the last decade. IITs and IIMs have faculty positions lying vacant for over 35% of them for again a decade, and the state public universities and private universities have over 50% of faculty positions lying vacant. In some ways, the problems of the law schools in India is a microcosm of the larger problem of universities in India, and that is the context in which an effort was made to build the global university. To cut the story short, sometime in the year 2006 and 7, I had the privilege to meet an Indian benefactor by name Naveen Jindal and persuaded him to do 3 things, which is to contribute substantial resources, commit towards doing it in a not-for-profit manner, and to let me have the academic freedom and functional autonomy and independence to build a world-class university. But the vision from the very beginning was to address the fundamental problem in Indian higher education as well as Indian legal education, which is to focus on the quality of faculty, and that alone being the driver of the effort to promote institutional excellence. Of course, we began in a very modest manner with only 100 students and 10 full-time faculty members in the year 2009, and David was there on 7th August 2009 when we had the semblance of the early state of a classroom with a broken staircase and no students and no faculty and no staff. That journey began on 7th August 2009, and we progressively moved towards today with over 2,000 law students and over 150 law professors full-time at Jindal Global Law School. In 8 years, this evolution of legal education has led to a situation where, when we started, we had barely 150 applications to the Jindal Global Law School, and every Tom, Dick, Harry and his cousin was admitted. But that evolution has led to a situation today when we have nearly 8,000 applications for nearly 400 seats, and I have had number of students leaving the leading national law schools to join us. And this is an example of what is potentially possible in India, in which the focus being on the quality and excellence that ought to be deeply embedded in the institutional imagination of creating institutions of global excellence. The new India is seeking to have this transformation. The aspirational India, which comprises of 850 million people in India who are less than 35 years of age, and are wanting to get that high quality education. 2 important aspects of this education need to be addressed, and I will indeed stop after that. These 2 are the challenges of the future of legal education. First, the effort to balance the need for promoting excellence, at the same time consciously committed to equity and access. To what extent our elitist institutions can balance this is going to be a big challenge. I strongly believe that elitism in institutions should pave way for promoting access as well. As an institution, we are deeply committed to that. Every year, over 70% of our students are studying with some form of scholarship or the other, and we intend to expand that and deepen that engagement. We also need to recognize and be conscious of what Harry Lewis in his book talked about, excellence without a soul. He talked about my another alma mater, Harvard University, and the byline of the book was How a Great University Forgot Education. And he spoke about Harvard University, and there is something fundamentally wrong at Harvard University. He says that the best of the graduating students think that their most meaningful career options lies in investment banks and consulting firms. This aspirational aspect of legal education need to be addressed through opportunities provided to students for being inspired by a number of imaginations, dogmatism, and any form of prejudicial thinking in any areas of politics, neither on the left nor on the right, is going to help. It is going to be based upon students making their choices as to how they will spend their life and careers, and faculty inspiring them to pursue a wide range of career opportunities. And that is the only way by which we will fulfill the desire of meaningful education while promoting excellence. The second aspect of legal education indeed ought to be towards promoting and strengthening the more deeper aspects of democratic governance, seeking opportunities for institution building, and also promoting diversity and pluralism within society. We cannot afford to ignore this aspect of it. One of the legitimate criticisms of the book could be the fact that the rise of the corporate sector need to be consciously tempered by the role of democracy and democratic institutions, and no better educational system than the legal education is best suited to advance that. It is important for law schools to be committed to that transformation, and that is the only way by which we will improve the quality of governance, but more importantly, help in building nations that are responsible and are able to speak truth to power. Thank you very much.
We're going to start with the commentators now that we've had the three papers. So would you like to start, Philip? Yeah.
Thank you. Good morning. Thanks for being here. These were great papers, and they touched on all the important issues facing the legal profession right now: education, law firms, their participation in legal education, and placements. We also heard from Professor Rajkumar how Jindal is sort of this new model, the new face of legal education. Now, I went to a legacy law school, the kind described by Nick. I went to the University of Pune, ILS. Thankfully, I didn't graduate too far ago, and I still have a very clear recollection of how life was at a legacy law school. I think we took great pride in the fact that legal education was cheap. I think that was the highlight of 5 years of education, that it was really, really cheap. At the end of, I still meet my classmates from that law school, and one thing we would constantly agree, 7 years out of law school, is we didn't spend any money getting that education. So whatever we got was just a bonus, which is very, very happy with what we got. Now, whether the national law schools, whether the new private schools are successful in addressing the demands of the industry, yes. They are making, producing, training better lawyers, period. Whether these lawyers choose public service, whether these lawyers choose to join big law, the corporate sector, that's their own choice at the end of the day. Yes, they are trying to meet the demands of the industry, which is a good thing. The world needs more and better trained corporate lawyers in India right now. They're helping build bridges, they're helping the economy, they are contributing to the success of the India story at the moment, and which is great. I, from my own experience, would recollect participating in two institutions that were sort of turning around almost about 7 years ago. One was obviously a legacy school changing to evolve and match up to a national law school model. They had introduced the 5-year course that I studied. The other model that has also changed significantly is the clerkship program. 10 years ago, clerkship program was this elite club where you were invited. There was no formal processes. I remember I interviewed at the Supreme Court to be a clerk, and my classmate, his interview experience was unique. A panel of 2 justices of the Supreme Court sitting at 5:30 p.m. in the evening, they looked at his CV and they asked him, "Oh, so you're a poet? Just let's hear some of your poetry." That's all he did. That's all he did to get into the clerkship program. The legacy law schools, the admission criteria was just how much you scored in high school. There was a interview process again, and my professor who interviewed me at that time said, "Oh, I have just one question for you. Who's the greatest lawyer you know?" I was an 18-year-old. I said, "My uncle." And he said, "Yeah, you're in." So those were the entry thresholds. And that's why it's great to see really strict sort of monitoring on who's getting into these law schools. This focus on training them well, the attention to detail that is required in the legal profession. And now sitting in a big law firm in New Delhi, when I see graduates who come in from these well-trained law schools, you really know that my work is in good hands. 7 years ago, I was a very underconfident lawyer stepping into a law firm because I knew my peers were much better, not individuals perhaps, but much better trained attorneys from the first day itself. Now most of them moved to private practice, a few of them are at the Supreme Court, some run NGOs, some are professors, and that's a life they chose for themselves. Law schools are not servicing the corporate sector, they're serving the country by just building great lawyers, training them, providing them the tools at an international standard. Most of my classmates now work across the world, and they take great pride in the education they received at their law school in India, and not just the LLM program that they did to get those opportunities to work in London or a New York or a Tokyo law firm. So from my own experience, both as a recent student at a student at an LLM program and working with a big law firm, I think law schools are doing a far better job than the legacy schools. Legacy schools would do much better to sort of learn from the National Law School experience, from the private legal education experience, and that's my 2 cents on how I see this playing out.
I just wanted to thank the authors for documenting what they did, because I don't think anyone has actually done that before, and actually reading Professor Khanna's chapter was like reliving my last year of law school when we were heavily dependent on RCC. Are we going to get a job, not going to get a job? So thank you very much for actually documenting this entire thing. I had a couple of observations on both legal education and the recruitment process. So on the legal education side, I think we are seeing a definite movement towards the 5-year program, but ultimately I don't think it's a question of whether we study for 3 years or 5 years, but it's actually the methods that the 5-year program brought in, which was just a more participative classroom teaching method, writing research papers, actually having vivas on the research papers that you wrote. So there was a definite consultation process with the faculty on which you were assessed. And I think the difference then between the people who came out of the 3-year and the people who came out of the 5-year program was quite perceptible, because when I went for the LLM, for example, there was somebody I knew who also went to the US the same year, who had gone to Delhi University, and I got a panicked phone call one day saying, how do I footnote? Because, you know, this person had never written a research paper, and I had done about 60 in my 5-year program, because you have to do one for each subject. So I think the legacy law schools could really think about the methods that they used to teach, and I think they could be as good as the 5-year law schools then. I do see some advantages of the 3-year program. One being that for the first 3 years after high school, people do a different degree. I think they have time to think about, do I really want to do law, versus a 5-year program where, you know, you're a 17 or 18-year-old out of high school and you think, oh, this looks good, you know, maybe I'll just do this. So I think the 3-year program does give people time to reflect. And because they do a different undergraduate degree, it definitely brings some perspective to their thinking. And I suppose they're a year older when they come out of law school. They've been to a different college, they've studied a different subject, interacted with different people. So I think at some level they may be more mature than the people who come out of the 5-year program. So I think, again, the legacy schools could probably be as good if they just rethink the methods that they're using. One difference that I saw between the teaching methods in the US and the 5-year programs in India was that the US just took it several steps further. And just yesterday I was reading an article about how a torts professor at Harvard Law actually held this awards program like the Oscars called the Torties, where he encouraged all his students to make short films. And I thought that was a great idea to learn, you know, and I just never heard of this sort of thing happening in India, but I think even the 5-year law schools could be more innovative we had, for example, partners from Wachtell coming in and teaching us M&A, and actually, what more could you ask for? Because this was a practicing lawyer who does these deals day in and day out. And he took 3 weeks off to come and teach us in a winter seminar. In India, practicing advocates are restricted from teaching. There is a limit on the number of hours I think they can spend on teaching. Otherwise, they have to surrender their bar council registration. So I think here we could do much more to encourage practitioners to teach in law schools, because that I feel can really bring a whole different perspective to teaching, and also prepare particularly final year students for the real law firm life, which when we see fresh recruits, we often see that they aren't as prepared as we thought they could be. And then on the recruitment side, the RCC chapter, like I said, it was like reliving my final year, but I was surprised to see how much it had changed, because so I went through the process in 2006-07. Hiring was not as competitive then as it is now. We were given job offers in our 5th year, and I believe that's been now pushed to maybe the 3rd or the 4th year. So the system we had was that in our 4th year, we elected 2 people from our class to be observers on the 5th year RCC committee, so that they could pick up all the knowledge, get the lists of the contacts, and figure out all the rules. And then we elected the rest of it when we entered the 5th year. And we at least didn't have these rules that the members of the RCC couldn't apply for jobs. They were equally involved in applying. Some of them were applying for the same firms, I think, as the rest of the class was. So there were no such restrictions then. But we obviously had to come up with a lot of our own rules. And at the time our RCC process was going on, the whole foreign firm hiring movement in India was picking up. So we had to sort of frame rules to deal with this new crop of Linklaters, Clifford Chances coming in. And I remember that we created, so we had band 1, which had like Amarchan, etc., and then we created like this band 0 with the foreign law firms, which were like above the rest. And from what I remember, again, like Professor Khanna was saying, we just had to evolve to what was happening. So I think we just came up with some rule that said that if you get offered a foreign firm job, you have to say yes or no that day, can't hold it. And if you say no, you can't, and you can only apply to 1 or 2, I think we had those sort of limitations as well. But I think they worked, because from the previous year, there were only 3 or 4 people who went to foreign law firms, but from our batch, there were about 10. So we sort of were able to maximize the opportunities. One thing that Nick said was that there is this danger of being, like the way legal education has evolved, I'm sorry, it just struck me now, and it's unconnected to recruitment, but the way legal education may be evolving is that students are now on this narrow path to corporate law. And when I graduated, I thought, there's nothing wrong with that, because even if I want to earn money for 2 or 3 years working in a big firm, there's nothing wrong with that. And I have enough friends who actually did that and saved up enough and then went to do what they really wanted to do. But now as a recruiter, I hate that, because as a firm, you invest so much in your associates, you train them, and then in 2 or 3 years they just say, well, we're done. And so from a recruiter, from a firm perspective, that is actually a real concern, because we may be forcing people to make choices that they don't actually want to make at the end of those 5 years. And I'm not sure what the solution is to that, but it is definitely a real concern now. And just coming back to recruitment, I think there's a lot more that law schools could do today to help recruitment. And again, when I went for the LLM, I was very, very impressed by the institutional support that Harvard gave with the Office of Career Services, where there would be people who would actually look at your CV and say, well, you should not write it this way, let's do it this way. We had mock interviews, and we had none of that when I was in college in India. And when I look at some of the CVs that come in now, I really wish that law schools would offer some sort of institutional support to these guys who are trying so hard to apply to firms, and offer the same sort of support that Harvard did. You know, have somebody review your CV, have them conduct mock interviews, and institutionalized recruitment itself. Look, why should the RCC run it? So Harvard organized a job fair. So I thought it was very, very well done, and a lot that Indian law schools could learn from that as well. I think in India we depend heavily on our alumni network. Like I know I did. Friends of mine from more senior batches were the ones who helped me out when I was applying for jobs. They were the ones who reviewed my CVs. But I think there is a lot we can do to change that.
Thank you, and I'll try and keep this as concise. The Shweta glare shouldn't reach, despite me being out. So I'm actually was quite moved by Nick's presentation of his chapter, and I think he's touched upon a problem which we are, I can say I'm a victim of, and it's something which is driving choice to get to law school, which I'll attempt to highlight is a problem, and why it will create a mismatch in the legal education and in the providers of corporate service, which are these very students who are reaching out to corporate law firms because they think that's the best thing to do. Interestingly, I went to a 5-year law school, and looking back, maybe I could have done things differently, and so happy to be here because at the back of the room there's Mukesh Bhutani, who in fact signed my reference for applying to law schools, and the reason why I'm mentioning that is that the choice for law back then, and this is, I'm ashamed to admit, way back in time now, 2001, was not driven by what the profession entailed, but by role models, at least speaking for myself. And being a litigator now, and having only practiced litigation through my internships and through my professional discourse, we looked up to people like Rajeev Luther, we looked up to people like Mukul Rohtgi or the stalwarts of the profession, and that's what made us think that okay, this is something noble enough to get into versus a job at a corporate law firm where I've been now 10 years and I enjoy it. The point I'm trying to make is that students these days are driven by the false requirement of getting a job at the end of 5 years, which is not what law school should be about. It should be about a learning of a discipline, which is now through the 5-year process an interdisciplinary process, and opening up avenues. I had someone who went to me for law school preparatory classes, who's now a DJ, and he's like, you know, with Bollywood, and he's not here on a Saturday on a panel wearing a suit and tie. He's happy, and so you know, the thing is, for a variety of reasons, and I don't know why, and I'll leave that for the academics to comment on. The promise of good paying jobs, as Nick put it, is driving students to legal education, which is the wrong promise. It is hopefully the passion for the subject, or what it could be a means towards, which is what should be driving students to law schools. And it's scary because we now have a common law entrance, which is good. It's organized, it's structured. It's very tough. I don't think I would have cleared it. I gave 10 separate exams at that time when I was applying for law school, and I wouldn't have if I didn't want to do law. But along with me at that time, and even now, if you see among the stream of applicants, are people who have also given the exam for the National Institute of Fashion Technology, and they're sitting for the law school exam. We were in a very interesting neighborhood in Calcutta in Salt Lake, where on one side there was NIFT, which was fashion technology. There was us in between the law school, and we had the National Leather Institute, which, with no due respect, made people who were going to service the leather industry. So we always had the joke that, you know, in the middle of the second or third year, if you didn't feel up to it, you have two very credible, good career options to explore in the neighborhood itself, which is precisely the problem we now see as sitting in a position where we are now as potential recruiters, that you see very misguided students coming to look for jobs. I do a fair bit of recruitment-related work for the firm, which exposes me to a variety of students, which is good, and it helps me preach, which tells me that, please think before applying for law school, for corporate law firm jobs. It may not be your calling. It may not be something you're trained to do because your calling lies elsewhere, but because it's fashionable, because it's the done deal to be in a band 0 or a band 1 firm is not what you should be motivated by. So that was just on Nick's point about who applies to law school and the means of the corporate law jobs driving students to legal education, which is a very, very scary proposition in my view. Tanya touched upon the 3-year versus 5-year programs, and I would strongly encourage people here or otherwise who are in thinking about this, or even the academics, that we all need to step back and actually see what happens at class 11 or class 12 in Indian schools, because there is a lack of serious counseling at that level to guide students as to what they should do. I was probably 1 out of 10 people in my law school batch who wanted to do law. The others were just there, because they probably didn't make it to the IITs or wherever else. But I wanted to do law, and that was driven by a variety of factors. But is that level of counseling and guidance available to students getting out of school? Probably not. So, the 3-year versus 5-year program debate is a classic one. You see students lose steam midway in a 5-year program. It can be intense if you want it to be. Whereas over a 3+3 process, you have a more paced out way of looking at whether you really want to do law. And I feel that for law as a discipline, both economics, philosophy, maybe politics, history are very strong input subjects which are taught in a brush in a 5-year law school. So when I happened to go for my master's program at Oxford, there were these very good courses which the undergrads were pursuing, which was, say, the PPE course, which is politics, philosophy and economics, and after that you move on to do law, which were very, very strong input subjects for whatever you want to do. It may be academics, it may be going on to become a barrister, it may be wanting to be in a corporate law firm, but your base was so strong that all of us who come out of the 5-year product are, I think, a quick fix to a law degree, which is creating a lawyer who can service a client at the end of 5 years, but are you based on good, strong foundations? I have no qualms in admitting I learned on the job. The internships that we did and the learning that you get as a first-year associate in a good law firm is what makes us stand in good stead today. But all of that could be improved much more if the choice made is correct, if the quality of education that you're getting is good, and you're actually choosing what you want to do versus going just with the flow. So I feel the 3-year programs still hold in good stead, including with the legacy law schools. Just a bit on the recruitment, and then we can all move for lunch. The value of the networks, I think, is great. I think, and what makes a difference is first impressions. And Professor Rajkumar spoke about Jindal, and I think it's a classic example of a law school wanting to make an impression and speaking through the alumni, because all of us had the backlog of National Law School, or the law school as they would like to call it, before we went into even getting a job, because the law firms at that stage were all flummoxed with NLS alumni, and they would look at any other law school in a very dim view, and I would now too, because I have to promote my law school in some way. So the jugaad does fit in, and that is where the alumni makes a huge deal of difference. And the problem, students from new law schools, and I hate to put Jindal there, is that they don't think what role they're playing in helping the rest of their batches get access to firms, because if one impression goes wrong, the law school's probably off the map, unfortunately, unless you find your way back in through some jugadu way of getting an internship and making such a huge dent that people start relooking at it. So yeah, I mean there's a lot to look at, even in terms of how colleges put up students for internships and recruitments, and now at the cost of being painful, at Amarchand we've now in fact started interviews for internship, because we were seeing that basis just the CVs you get, it's a lot of fluff because there's no filtering. and you then get a student in who's not worth it, he's not assigned for the job that he's come out for. So we have in fact started now interviewing candidates even for the internship, which is a strain, but it is at least allowing them to get a good intake of interns who we then may want to take on as future recruits. So yeah, it's tough to be a law student now, or I would imagine as it was even when we started off, but it's definitely an exciting industry to be a part of. Thank you.
Thanks, Anuj. He misquoted a little bit. We're not going to go to lunch yet. Part of the reason I've been giving the Shweta stare to everybody is because we have like this amazing opportunity to actually be in conversation with all of you. I know a lot of you are law students, so what I urge you to is put your hand up. I'm going to stand up. Wow. See, it made sense that I kept giving people stares. So put your hand up. If you could, there are people with mics walking around, so Brian and Catherine are both going to have mics around. If you could introduce yourselves very quickly and ask the question, I'll collect questions, then we'll do 3 minutes per panelist. Does that sound good?
Bias towards younger.
Yeah.
To come and realize, to come down to the earth level that no, you are not somebody special as you have been made up to be, because you have written 100 paper in 5 years course. So coming to that, these people, I think you need to have a very journalistic approach also. You should not be super specialized. I'll give you an example of a case. It was a Maharaja's property dispute. A top law firm, band 1 law firm, hired a band 1 lawyer from Delhi to argue in Jodhpur. Now when the judge put a question that I will not take this paper into admission because 1 rupee stamp was not put on it, it was not affixed on it. That lawyer could not comprehend, and he is a band 1 lawyer, what is the importance of 1 rupee stamp on this 850 crore property dispute. So I think you need to have a holistic approach towards your student also. They become so super specialized that they don't understand the ground realities. Then coming to the more example of your competition law. Yeah, I am telling you. So I am telling you, for the 5-year law school students, you need to give them a holistic approach, right? For the competition law and even for insolvency law. The cases which are struck down is not on the particular provision of those laws, but on the general aspect of there is a violation of principles of natural justice. This aspect has been able to be brought about only by the experienced lawyer. So my only question is, how do you give them the more general approach than making them a super specialist that I am seeing the lawyers who are coming to courts.
Thank you. So we have a lot of questions, so if we can keep it really short, ask your question and then we'll...
I'm Kavya Agarwal and I'm from Jindal Global Law School. My question is that, the established law schools, which are basically, we call them legacy law schools, they have a much more established name than the newly private universities that have come in. So how does, as a student, the university name plays a role in our career in the future in the legal fraternity?
Great question.
Good afternoon, everyone. Thank you for your time and this opportunity that I can ask a question. My question is in context of the accessibility to the legal education in the time when fees is increasing and the promise is about the job opportunity. Is demand being created to sustain the vested interest, or is demand based on the supply of legal services?
Good afternoon. I'm from NLU Kolkata. I'm a 4th year student. I have 2 questions, very short. When we talked about the diversity at NLUs, a lot of time we divide people into privileged and non-privileged strata. But then I haven't come across a point of view that that divide in privileged and non-privileged strata is also because of an NRI quota which exists in the law schools. So my personal experience told me that those 10 to 15 people from the NRI quota which are coming in every batch are exactly the people who are excelling in moot court rounds or maybe in law reviews or maybe in foreign law firm jobs, because before coming to the law school they were studying in the supremely creamy layer schools which gave them all that exposure. So when we are talking about bridging that divide and when we are talking about diversity, is it the time that we reconsider that quota? That's my first question. And the second is that when we are talking talking about this channelization into the corporate sector, we are not looking at the fact that students are sort of forced into going into that. So from my personal experience, I think there are 3 reasons people go for corporate jobs. One is because they have interest, very rare. Second is they have peer pressure. And third is that they have the element of fee. Now my question from that is that, is this the time that we should start nationalizing NLUs? Because a lot of people, and I'm talking about the common people who do not know that national law schools is just a misnomer, because they are not national in the sense of being centrally associated. I myself was drawn into national law school thinking it's a national law school. After coming there, I realized it's a state university funded by state, and hence the fee level and every problem is emerging. So is the solution the nationalization of NLUs? Thank you.
Thank you.
Dignitaries on the dais and very expert on board David, I salute you to select your book. It is a very celebrated. I feel it is just called just like a Bible, just like the Gita and Ramayana or Mahabharata. Whenever you are confused, you open the book, these religious books, you get answer. At the same time, I am giving the realities of this profession. People come, sometimes they see the films, they see the acting, advocacy and all, they enter into it. The basic is that the realities are this, of this profession, that when you start this profession, you feel that you are a lawyer and you are advocacy. My great guru, Dronacharya, Nani Palkiwala, the only jurist India produced on the record. Off the record, there are so many jurists, they become the honorary jurist associations members and all, they call them jurists. That only jurist is with the kingdom of God now, you see, the Nani Palkiwala. Still today, these young lawyers, they are the coming generation of the legal profession. And the result is this, that today even the judiciary, lower or higher, they are going with the century-old acts, 1860, 1903, 1910, more than century. No commas, full stop, and other amendments are made in those books. What I request, you see, the law schools, they should produce the students well versed with it. What Nani Palkiwala, my Dronacharya is my guru, said that, remember, ethics is the number 1. Etiquettes, number 2. Number 3 is hard working. Otherwise, you will not be a great lawyer, you don't expect. Other guru, the known advocate of Delhi, his name was all over known. That was, you see, I mentioned him, Mr. Vikramaditya, Jugaad. When I gone to him, you see, for the criminal law lessons, he told me, what is criminal law? Then some client came and he has murdered somebody. And he told him, come by nearer to me. He slapped him and the blood was not there. He said, yes, blood has not come. I was very surprised. That was my first day, you see, with him. So I said, what he is doing? Is he a fanatic? He is a mad? Then, he said, now you go to the police station and get a report and have a treatment, then come to me. So he was known, the great lawyer in Delhi who fought the cases of this Chopra, brothers, sisters, and he used to create the evidence and then fight the case. Ultimately, he was shot dead by some client or some, in his cabin. So this was the condition over there with these 2 lawyers. Then I left him, I started my...
So this is a great story, and we're so excited we're able to share this, but there are a few more hands, and I want to make sure everyone gets a chance to speak.
Yes, I will cut short it, but these are realities, Then I gone to this for the other practice, that is matrimonial. And my mother, in 3-4 days, she said that don't start this practice because people say that you are breaking the houses, breaking the families. I said, how I am doing like that? He said, you are speaking untruth, all everything, see. So don't do it.
So the great thing is we have lunch after this, and I know people are going to want to hear more about that story, but we're going to have to go to a couple of more hands right at the back. Thank you. Sure.
I am Prashant. I have a management consulting firm. The only thing I just wanted to check, because my daughter has joined Jindal Law School and she got into NLU also. So she joined Jindal Law School because she was passionate about pursuing law, and she saw the services, the facilities, the professors that Jindal Global Law School has. But you as law firms, do you differentiate when you hire from NLU versus Law Fac versus Jindal Global? Is what just wanted to understand.
Even if they do, they're not going to tell you.
That's true. So it's great, yeah.
Sorry. Hi, my name is Ojasvita. I'm an in-house counsel. First of all, congratulations to the entire panel. It was a fantastic discussion. Very pinpointed question, coming to the point of changes required in the legal education in the context of opening up of the Indian legal industry. Now, we have the American legal industry alone, which is $437 billion worth, of which law firms are $237 billion alone. All of Indian legal industry put together is only $1.25 billion. So in that context, what sort of changes are required in the Indian legal education to survive that onslaught? And I would like to emphasize on the aspect which Professor Rajkumar mentioned, on the aspect of diversity. So we have 1,550 colleges all over India, which are producing 80,000 law graduates every year. So in that context, what sort of changes do we need in the legal education so that we can survive that sort of an onslaught?
So we have time for maybe 2 or 3 more questions, and I really want to give the panelists some time to respond to this because these are really rich questions.
Hello, I am also from OP Jindal Global University. I am doing law. I am in my second year. So first of all, I must thank you all for coming to this panel right now and for such a fruitful discussion. And I must commend Professor Raj for the excellent work in the MOU you've done with Cornell University. So my question is actually related to the MOU. My question is that how big of a factor would such collaborations and partnerships with foreign universities be in the future for a 5-year and a 3-year program? And is there a difference between the recruitment that happens after the 5-year program and after the JD program that's been added after the 5 and 3-year program? And
Great.
That question would be probably for the entire panel in relation for recruitment as well. Thank you.
Thank you. So we have a couple of hands that have been up for a while. So, like I said, the great thing about this is that we have lunch after this. So find the panelists and have long conversations. One more question, sure.
Good afternoon, everyone. My question is about recruitment process. Like there are lots of colleges like tier 1, tier 2 colleges, all the government, including all the governments and the private colleges, like NLU, Delhi University. What about those colleges which are in the very remote area of the country, like Siliguri, like any part of the country which is remote, but there are private colleges, newly opened private college, or the state-owned government colleges. So is there any recruitment process apart from Jugaad and that student sale and that other the recruitment process through the agencies and all? So is there any process through which one can directly apply for the big law firms? And second thing, like if they are 5-year student, as the ma'am mentioned, Tane ma'am, like if they are 5-year student, definitely I agree with her, they are having the more skill in the field of research. In the 3 years course, it is lacking. But ma'am, in the 3 years course, there are the subjects, hardly it gave a time to go for the research. So what are the faults of those students who are going through the 3 years? Thank you.
Thank you. So I know there are lots of hands up, but we really need to cut this short now. So we're going to give the panelists a few minutes to respond to this quickly, and then we cut for lunch where seriously, they're all going to be there, so get to them. Nick.
Should I start?
Yeah, sure.
Okay.
Yeah, 1 minute a person, and then you get the Shweta glare.
Okay, I wasn't kidding. So there's 2 minutes. I'm happy to talk to people after. I'm just going to focus very briefly on this fee issue, which keeps coming up. And I do think there's a real question, for example, if there is sufficient demand to take in all of these law students who have these aspirations of going into the corporate legal sector. As we heard yesterday, the corporate legal sector is actually quite small. In India, this is a challenge that the U.S. has been facing as well. Law school is incredibly expensive there. Not all the graduates are getting the high-paying corporate law jobs they were expecting when they entered, which is really creating a crisis in legal education. But there's a genuine tension here that also keeps coming up, which is people are like, well, we need lawyers who can write well. We need lawyers who can research well, who can speak well, who can think critically, who can think like a lawyer, who have this network that can get them where they're going. All these things cost money, right? And this is, I think, particularly true in a country like India, where you have generations who are coming up whose parents didn't necessarily go to college themselves, or the college education they got, maybe they can't kind of bestow those critical language skills. Oh, I'm getting the stare. And so I think this is a real tension that has to be navigated in how much the Indian government, with its limited resources, wants to put that into education. And so this is going to be a constant dance going forward.
Okay, I'll try to be very brief because I'm trying to avoid the stare too. Briefly, I very much like the idea of people having more time to decide what they want to do. Just because usually giving someone 1 more year to decide what they want to do is usually better than giving them a lifetime to regret their choices. So that, I think, is generally a good idea. Of course, the issue is what you actually teach them in those years. So that if 3 plus 3 is just 3 of not much substance followed by 3 of not much substance, I would prefer 5 of substance. That's one thing. The second thing is, in terms of the issue of fees and things like that, one way to think about it is even in countries that have low fees for legal education, there's a tendency to move towards the higher paying jobs, and that just indicates how people are thinking about education. It's an investment. So the issue is not really the price tag at the front end, the issue is what you're seeing at the back end. And that's partially motivated by the fact that there's a lot of pressure on the corporate side. As we mentioned yesterday, there are 13,000 corporate attorneys in India. As I think Mr. Hassani mentioned, not too many of them can do the high-end work that they need. That's 2 orders of magnitude less than what you'd see in the U.S. In the U.S., there are 900,000 corporate attorneys. That's where all the pressure for the high salaries is coming from. Final point I would make is that obviously law firms make distinctions amongst candidates. They can't hire everybody. That's certainly the case. Whether they base it on the school or base it on other things depends a lot on what the institutional legacy of your school is. If your school has a good reputation for producing high-end talent, they're going to be inclined to look at that school more. If they're not sure what your reputation is yet, you're very new, they might either decide not to look at your school, or they might decide to only look at candidates who somehow differentiate themselves, whether it's in the hinterlands or whether it's in the cities, that somehow find a way to differentiate themselves from the rest of the pack.
All right, well, most of the questions are hugely connected to, in some ways, the relationship between education and the income earning capacity of people after who graduate from the degrees. I strongly encourage you to read a very important book on this. On the larger context of the focus in society today, it's author Michael Sandel, What Money Can't Buy, The Moral Limits of Markets, looking at the whole context of measuring everything that we do in society in monetary terms. The consequence of that society is corruption and inequality. I want to emphasize the point because many students and maybe even parents look at investment in education from the standpoint of the immediate job that they get after they graduate. A return on investment in education is not seen in that. It's the next 60, 70 years of your life, what you're going to be doing, and everything that you're going to be doing in the years and the decades to come will be to a large extent determined and measured in relation to what kind of educational experience you've had. And that's a very important aspect of it. Fees, correlation between, this is another unfortunate thing in India. I went to Delhi University. I'm proud of that. The law faculty at Delhi University. I spent something like $30 for my legal education. And I believe that obviously Delhi University spent a lot more. I spent far less on my legal education than my undergrad education, which was significantly less than my school education. It's just a completely misgoverned enterprise. I think there should be a direct correlation between the cost relating to an institution and the fees that is charged. So unfortunately, subsidies in this matter has created false dichotomies in which certain institutions are privileged over the others. And I think we need to, at a policy level, address it. But from a student standpoint, I hope you will. We have come a long way from nationalization. The idea of nationalization of national law schools is not just a desirable thing, but also it would not fulfill the objectives of what you would want to, which is to, let's say, make education accessible to people, and that has to be based upon a stronger focus on scholarships and endowments and providing that access. Lastly, I think it's also useful to mention that I don't believe that there is any systemic forms of discrimination either on account of new or old, public or private, at least at the employer standpoint. I think what happens is in the early phase of any institution evolution, it takes time. So if you look at a national law school in Patiala or Raipur or Gandhinagar or Bhopal or Nagpur or Mumbai, they have a different situation as opposed to older ones. But what is going to make a difference is that how each of those institutions are able to provide legal education which can empower the students and which in turn lead to the jobs. I think it's fair to say that not just our schools, but many private law schools, but also other newer public institutions have had fantastic recruitment. I was pleasantly surprised that Shardul Amachan recruited 15 of our graduates just a couple of years ago in one go. I don't think it's about that aspect of it, but yes, it's important that education ought to be the focus of it, and quality education offered to students will in turn lead to that. But the larger issue that I'm worried about, the vibes that are coming, is that legal education is not just about getting into corporate law firms. There are lots of other meaningful opportunities and careers that one can pursue and one which can be fulfilling. And it's important that the legal education experience provides you that inspiration to pursue those opportunities. And it's unfortunate that many law schools have actually positioned itself, including the National Law School, that the best of the students ought to be getting into the best of the corporate law firms. It's a tragedy that has come about on the law schools, and we as educators in particular, I don't expect much from the corporate law firms on that, but we as educators need to challenge that, resist that, and help transforming that.
Okay, with that energetic last comment, I think we're going to break for lunch. We're only 35 minutes late, so we're practically on time as far as it goes. We're going to come back at 2:30 for the next panel. Okay, thank you, everybody. Thanks to the panel.
To come and realize, to come down to the earth level that no, you are not somebody special as you have been made up to be, because you have written 100 paper in 5 years course. So coming to that, these people, I think you need to have a very journalistic approach also. You should not be super specialized. I'll give you an example of a case. It was a Maharaja's property dispute. A top law firm, band 1 law firm, hired a band 1 lawyer from Delhi to argue in Jodhpur. Now when the judge put a question that I will not take this paper into admission because 1 rupee stamp was not put on it, it was not affixed on it. That lawyer could not comprehend, and he is a band 1 lawyer, what is the importance of 1 rupee stamp on this 850 crore property dispute. So I think you need to have a holistic approach towards your student also. They become so super specialized that they don't understand the ground realities. Then coming to the more example of your competition law.
You have a question.
Yeah, I am telling you. So I am telling you, for the 5-year law school students, you need to give them a holistic approach. right, for the competition law and even for insolvency law. The cases which are struck down is not on the particular provision of those laws, but on the general aspect of there is a violation of principles of natural justice. This aspect has been able to be brought about only by the experienced lawyer. So my only question is, how do you give them the more general approach than making them a super specialist that I am seeing the lawyers who are coming to courts?
Thank you. So we have a lot of questions, so if we can keep it really short, ask your question, and then we'll...
I'm Kavya Agarwal and I'm from Jindal Global Law School. My question is that, you know, the established law schools, which are basically, we call them legacy law schools, they have a much more established name than the newly private universities that have come in. So how does, as a student, the university name plays a role in our career in the future in the legal fraternity?
Great question.
Good afternoon, everyone. Thank you for your time and this opportunity that I can ask a question. My question is in context of the accessibility to the legal education in a time when fees is increasing and the promise is about the job opportunity. Is demand being created to sustain the vested interest, or is demand based on the supply of legal services?
Good afternoon. I'm from NLU Kolkata. I'm a fourth year student. I have two questions, very short. When we talked about the diversity at NLUs, a lot of time we divide people into privileged and non-privileged strata. But then I haven't come across a point of view that that divide in privileged and non-privileged strata is also because of an NRI quota which exists in the law schools. So my personal experience told me that those 10 to 15 people from the NRI quota which are coming in every batch are exactly the people who are excelling in moot court rounds or maybe in law reviews or maybe in foreign law firm jobs, because before coming to the law school they were studying in the supremely creamy layer schools which gave them all that exposure. So when we are talking about bridging that divide and when we are talking about diversity, is it the time that we reconsider that quota? That's my first question. And the second is that when we are talking about this channelization into the corporate sector, we are not looking at the fact that students are sort of forced into going into that. So from my personal experience, I think there are three reasons people go for corporate jobs. One is because they have interest, very rare. Second is they have peer pressure. And third is that they have the element of fee. Now my question from that is this the time that we should start nationalizing NLUs? Because a lot of people, and I'm talking about the common people who do not know that national law schools is just a misnomer because they are not national in the sense of being centrally associated. I myself was drawn into national law school thinking it's a national law school. After coming there, I realized it's a state university funded by state, and hence the fee level and every problem is emerging. So is the solution the nationalization of NLUs? Thank you.
Thank you.
Dignitaries on the dais and very expert on board David, I salute you. You salute your book. It is a very celebrated. I feel it is just called just like a Bible, just like Gita and Ramayana or Mahabharata. Whenever you are confused, you open the book, these religious books, you get answer. At the same time, I am giving the realities of this profession. People come, sometimes they see the films, they see the acting, advocacy and all, they enter into it. The basic is that the realities are this, of this profession, that when you start this profession, you feel that you are a lawyer and you are advocacy. My great guru, Dronacharya, Nani Palkiwala, the only jurist India produced on the record. Off the record, there are so many jurists, they become the honorary jurist associations members and all, they call them jurists. That only jurist is with the kingdom of God now, you see, Nani Palkiwala. Still today, these young lawyers, they are the coming generation of the legal profession. And the result is this, that today even the judiciary lower or higher, they are going with the century-old acts, 1860, 1903, 1910, more than century. No commas, full stop, and other amendments are made in those books. What I request, you see, the law schools, they should produce the students well versed with it. What Nani Palkiwala, my Durranacharya is my guru, said that, remember, ethics is the number one. Etiquettes, number two. Number three is hard working. Otherwise, you will not be a great lawyer, You don't expect. Other guru, the known advocate of Delhi, his name was all over known. That was, you see, I mentioned him, Mr. Vikramaditya, Jugaad. When I gone to him, you see, for the criminal law lessons, he told me, what is criminal law? Then some client came and he has murdered somebody. And he told him, come by nearer to me. He slapped him and the blood was not there. He said, yes, blood has not come. I was very surprised. That was my first day, you see, with him. So I said, what he is doing? Is he a fanatic? He is a mad? Then, he said, now you go to the police station and get a report and have a treatment, Then come to me. So he was known, the great lawyer in Delhi who fought the cases of this Chopra, brothers, sisters, and he used to create the evidence and then fight the case. Ultimately, he was shot dead by some client or some, in his cabin. So this was the condition over there with these two lawyers. Then I left him, I started my...
So this is a great story, and we're so excited we're able to share this, but there are a few more hands, and I want to make sure everyone gets a chance to speak.
Yes, I will cut short it, but these are realities, Then I gone to this for the other practice, that is matrimonial. And my mother, in 3-4 days, she said that don't start this practice because people say that you are breaking the houses, breaking the families. I said, how I am doing like that? He said, you are speaking untruth, all everything, so don't do it.
So the great thing is we have lunch after this, and I know people are going to want to hear more about that story, but we're going to have to go to a couple of more hands right at the back. Thank you. Sure.
I am Prashant. I have a management consulting firm. The only thing I just wanted to check, because my daughter has joined Jindal Law School and she got into NLU also. So she joined Jindal Law School because she was passionate about pursuing law, and she saw the services, the facilities, the professors that Jindal Global Law School has. But you as law firms, do you differentiate when you hire from NLU versus LawFac versus Jindal Global? Is what just wanted to understand.
Even if they do, they're not going to tell you.
That's true. So it's great, yeah.
Sorry. Hi, my name is Ojasvita. I'm an in-house counsel. First of all, congratulations to the entire panel. It was a fantastic discussion. Very pinpointed question, coming to the point of changes required in the legal education in the context of opening up of the Indian legal industry. Now, we have the American legal industry alone, which is $437 billion worth, of which law firms are $237 billion alone. All of Indian legal industry put together is only $1.25 billion. So in that context, what sort of changes are required in the Indian legal education to survive that onslaught? And I would like to emphasize on the aspect which Professor Rajkumar mentioned, on the aspect of diversity. So we have 1,550 colleges all over India, which are producing 80,000 law graduates every year. So in that context, what sort of changes do we need in the legal education so that we can survive that sort of an onslaught?
So we have time for maybe 2 or 3 more questions, and I really want to give the panelists some time to respond to this because these are really rich questions.
Hello, I am also from OP Jindal Global University. I am doing law. I am in my second year. So first of all, I must thank you all for coming to this panel right now and for such a...
For those of you who had the chance to be with us last evening, we had amazing discussion about that from Justice Chandrachud and from Fali Nariman and from our amazing panel. But today we're going to go into a little bit more depth on thinking about the role that lawyers are playing in really two critical arenas in India's development. One is the courts. India has an incredible tradition of its judiciary, and a critical part of that judiciary is its senior advocates. And it's a system that's somewhat unique in the world. Maybe you could say it's based on the English QC system, but it's developed its own unique attributes. That's part of what we study here. And we're just thrilled that our colleague and friend Nick Robinson, along with Mark Galanter, who I'm sure he'll talk about, who's sort of a legend to many of the people in this room, have written a paper about India's grand advocates, as they call them, and how globalization of the legal profession and the rise of the corporate sector and the things that we've talked about are affecting this incredibly important part of India's bar, and through that the judiciary. And we are so thrilled that Swami Kumar, who is one of the best examples of what Nick and Mark have studied, one of the grandest of your senior advocates, a former Minister of Law and Justice, has agreed to give commentary. So Nick will speak first, then Mr. Kumar, and then the second group of speakers and panelists looks at another important area of the role of lawyers in the state, and that's the role of Indian lawyers in let's call it legislation, or the creation of legislation and public policy. And we are thrilled that Bhargavi Zaveri from IGIDR, a research think tank, has written a quite brilliant paper about this. And I'll just say, for those students in the room, since this may not come up, Bhargavi was already a prominent rising star lawyer in a law firm when I met her maybe, how many years ago? 5 years ago, I think this was. But Bhargavi had the courage to say, you know what, I think I want to have a change in my career, even though she was doing very well. And so she said, there's a part of your project I don't think you're looking at, which is what is the role of these lawyers in the legislative process and how that's changing over time. And I said, boy, that would be terrific. And she said, I'd like to maybe work on this project. And so she quit her job, and she took a research leave to come to the United States, wrote a brilliant paper, and then really this has launched her on a whole new career. So when you think about what you can do with your law degree and how you might change from what you do initially to what you might end up doing, I think Bhargavi is a great story. So Bhargavi will present her paper, and then Mr. Bharat Vasadi, who is the former general counsel of Tata, now a senior advisor to the chairman, will provide comments. For those of you, I said last night, Bharat has been such a great friend of this project from the very beginning and one of the most thoughtful people that I know, and the Tatas have been a critical part of this story, and Bharat has been right in the middle of it. Mr. Rajeev Luther is trying to join us. Those of you who know Rajeev know he's got lots of things going on all at once. He's now called us several times. He's on his way, but I'm not sure he'll make it, and if he doesn't, we'll much regret his absence. But Shahana Basu, who's also a general counsel and who's also thought a lot about these issues, has agreed to step in if Rajeev doesn't come. So watch that chair over there, and if we get to you, we'll have Shahana offer us a few words. So with that, I'm going to turn the podium over to Nick. No, you have to stand up. No, you
have a more academic thing I like that, just to stay seated. Thank you again, David. I'm kind of doubly sorry here in the sense that you already heard me in the last panel, so you have to hear me again a second time shortly thereafter. And then I'm also sorry because Mark Galanter As David mentioned, who I wrote this chapter with, isn't here, couldn't be here with us in India today, and he really is a legend in terms of his work on Indian law more generally, on the Indian legal profession as well. And if you haven't read Mark's work, I very much urge you to go, and especially students here, to go and read some of Mark's work. I'll also say, if there's any kind of praise you want to give for this chapter, give it to Mark. And then if there's any, if you disagree, that was probably me. I think this is a chapter that we wrote about what we term grand advocates, and I think it's a relatively easy piece, I think, for a lot of lawyers, but even for the general public to engage with. Because what we call grand advocates are just so well known within the Indian legal profession, but also, in middle class families across India will know the names of many lawyers that are appearing before the Supreme Court and the High Courts. And this is, I think, unique to South Asia, as David was mentioning. There isn't really anything comparable, say, in the United States, in the United Kingdom, in France, in Germany, in other countries, to have what we describe as lawyers, right, that occupy in this kind of steep hierarchy of lawyers with outsized prestige, authority, and prosperity. So they're well known across the Indian public. They frequently appear in big name cases. They generally have lots and lots of matters in court. And of course, they typically charge a lot to appear for these cases. And one of the ways they have been affected by liberalization is they arguably get to charge even more now, post-liberalization, as the economy has grown. But what's, I think, interesting about this that we pointed to the paper is that this is a structure to the profession that was clearly there during the colonial era. It was there in the post-independent era. And it's continued, perhaps somewhat surprisingly, post-liberalization. You can find grand advocates all through kind of the history of the Indian legal profession. One thing I should note just at the outset, because I get asked this question a lot, is we don't make a list of who are grand advocates. I can't tell you this, this person's a grand advocate or that person's a grand advocate. It's more of an amorphous category. I think, for example, in the chapter we say, maybe there's like 50 of these individuals in the country. Some people we talked to disagreed, and they say there's none. The last one was H.M. Survey, and he passed away in the 90s. And there's, no grand advocate since. Other people we talked to is, any senior advocate with kind of a successful practice should be considered a grand advocate. So we argue that it's probably somewhere in between. We also don't make a normative judgment about whether it's good to be a grand advocate. Maybe it's personally good to be a grand advocate in terms of prosperity and prestige, but whether this is good for the Indian legal profession or for the country, right? That's a separate normative issue, and I'll touch on that again just at the end of my remarks. Our argument in the chapter is that the presence of these grand advocates largely comes out of structural factors about the Indian court system. So this isn't an argument about Indian culture, that there's just something hierarchical about Indian culture. It's not an argument about charisma, although many grand advocates are charismatic. But it's something structural about the courts that generates this kind of lawyer. So first of all, part of the reason you can have such well-known lawyers is because the courts are so central to Indian political and economic life. If the courts weren't as central to Indian political and economic life, you wouldn't have this kind of lawyer manifesting itself. Second, in those courts itself, they prize oral proceedings over written proceedings, right? So it's about advocacy, right? It's not about the written brief. It's going out and appearing before judges, often in crowded courts, in an overwhelmed judiciary. So this prioritizes what is popularly known around here as face value, right? So that certain lawyers in these crowded courts, in these crowded contexts, can get admission for matters, that they can ask for postponement, and they're more likely to have those requests taken. It also means that because these are crowded courts, these are often very procedural questions that these lawyers are appearing for. So they can hear, they can be appearing for literally, a dozen matters in a day, because these often are just very small procedural matters. You also have a situation where judges are, we would argue, in a relatively weaker position compared to many other systems in the world. So what do I mean by that? One is that, just to be quite honest, and this isn't kind of news, is a lot of the talent in the bar stays in the bar and goes up into these grand advocate positions or now into corporate law firms, and doesn't necessarily go to the bench, right? That's not to say that there aren't many talented lawyers who are judges on the Supreme Court and the high courts and elsewhere. But this creates a bit of an asymmetry between some of these lawyers and between the judiciary. Also, these judges are moving often, right? So, and they have to retire early, relatively early in their career, so in their early 60s or 65 if you're a Supreme Court judge. So what this means is that these lawyers, these grand advocates, have been around these courts and are far more of an institution in these courts than the judges themselves. Also, so the grand advocates also tend to have more cultural capital than the judges. So what do I mean by that? They're kind of networked in better. They often have English as a first language as opposed to English as a second language. And then finally, there's an unpredictability to the jurisprudence in India, where you have a system, for example, in the Supreme Court, where there's many benches, in the high courts where there's many benches. And you're not always quite sure what kind of order you're going to get out from any given judge. And in this system, there's a lot of incentive for clients to go and find out these best known grand advocates, these most senior advocates, to try to guarantee in this kind of more confusing morass of jurisprudence, the result that they want. Kind of last point on this is that the reputational capital that these grand advocates develop, we argue in the paper, is a positional good, in that it's difficult to transfer to others. So for example, if you're in a corporate law firm, you can put the names of the managing partners on the law firm. And then those law firms can kind of look over junior associates, monitor work product, and then hand that work product over to the client. Grand advocates can't do that. You need the grand advocate to show up in the courtroom, right? And present that. You can't send your junior, right? It doesn't have the same effect. So the flourishing of grand advocates is very much intertwined with features of the Indian legal system, such as congested courts, insular social networks, overwhelmed and under-resourced judges, and the centrality of the judiciary in Indian political life. And these have all, interestingly, continued post-liberalization. So the last point I want to emphasize here is that we look at in the chapter is what has been the effect of these grand advocates on the Indian legal profession and on the Indian court system more broadly. We don't come to a conclusion on this, but I would just say that it's not obvious what the effect of having this kind of elite stratum of grand advocates have been. Certainly when we wrote this, we interviewed a lot of advocates, including a number of younger advocates who expressed a lot of resentment, quite frankly, towards some of these more senior advocates. And they said, they resented a couple of things. So one was the feeling that to succeed in litigation, and we've heard this multiple times already, that you need family connections, or you need kind of a quote-unquote godfather to help you get into litigation in the first place. So it doesn't seem as meritocratic. They think the grand advocates that exist out there have too much work on their hands, and so as a result spread themselves too thinly. As a result, the work product suffers, and so the jurisprudence coming out of the courts also suffers as a result, because the judges aren't getting briefed as well as these advocates could if they had fewer cases. The grand advocates also have so many cases often on any given days. They're always asking for stays and delays because they can't make it to necessarily every courtroom. And this contributes to the delays in the proceedings in courts, and so the backlog of the Indian judiciary. On the other hand, we certainly heard a kind of a counterpoint to this, often from grand advocates themselves or senior advocates, but from others as well, which have a more optimistic take or a positive take on the role of grand advocates in the Indian judiciary. So here arguments are along the line of, that they're able to inform judges, right? They have many of these advocates have just an encyclopedic knowledge of the law, a very deep understanding of the law, and they're able to pass this along to the judges, who then are able to put into their opinion, that they're able to take more novel lines of reasoning, and the judges are willing to go along with this. So for example, one case that you might think about this with is the famous Keshavan Bharati where Palkavali argued for the basic structure doctrine. And arguably that gave some cover to the Supreme Court judges to take on this novel line of reasoning. And then finally that they express that they view themselves as guardians of the court and of the rule of law. So with that, I just want to end with two questions about grant advocates and kind of thinking ahead here. So one is, do we think this era of grant advocates is ending, right? Can we expect, if we to come back and write a similar book to this in 2030 or 2040, will there still be this kind of distinct sort of senior advocate that is out there that's readily identifiable back to the colonial era and the post-independence era? Are there pressures about either reforms in the judiciary that will narrow the space for these advocates, the tribunalization of the judiciary, which will give less space to these advocates, the rise of law firms, which might put pressure on these advocates as well? And then one aspect of this chapter that this chapter touches on, but doesn't really go into depth, but I'd love to explore more here, is the political role of grant advocates. And as you know, certainly, sir, grant advocates have been intimately involved in politics in India, and this goes way back, whether you're thinking about Motilal Nehru or Jinnah. They've been legal officers for the government. Some have been politicians themselves. Some have viewed themselves as guardians of the court. And how would we best describe their current political role and what we envision what their future political role should look like? How prominent is their voice now? How prominent it should be? And compared to other lawyers, as we'll hear about, who are having more of a role now in advising the future of politics in India. So I'll leave it to that.
Thank you, Nick. Mr. Kumar, thank you. Please, would you like to come here?
Thank you, David. Thank you, Nick. Distinguished members at the podium, ladies and gentlemen. All I can say is that when summoned by David Wilkins, I could hardly say no, because he has been such a gracious host to us. When I say us, it included the then Chief Justice of India, Tamash Kabir, Justice Swatantra Kumar, myself, and one or two other judges of the Indian Supreme Court, when on their invitation we visited the Harvard Law School, and we had an excellent 3-day trip to the school, and we were all, as always, impressed by the high degree of learning and education and the skills that are associated with the training of lawyers at the Harvard Law School. More recently, in 2016, I had the pleasure of being with you again, and I had the great honor of meeting, amongst others, Frank Michelman and Dean Alford, a number of other very, very distinguished jurists, interacting with whom alone was quite a treat. So when I was told that David is putting together this group and he would like me to come and speak, I was delighted. I'm sorry I couldn't come yesterday, I was a bit indisposed. But to respond now to what Nick mentioned as the doctrine of grant advocates, or grant advocacy, quite clearly we had this group of very eminent counsel throughout our history, and more particularly in the pre-independence era and immediately after independence. Most of the stalwarts of Indian freedom movement were lawyers, beginning with Mahatma Gandhi, Motilal Nehru, Jawaharlal Nehru, Sardar Vallabhbhai Patel, K.L. Mishra, and you can just keep counting, even Vallabhbhai Patel. Dadabhau Naoroji, Surendranath Banerjee. These were the founders of the Indian nation. These were the founders of the Indian Constitution, Dr. B.R. Ambedkar. They were grand advocates in an entirely different sense in which the grand advocates have been described and emphasized in your book. I guess this was in response to the changing demands of a changing society, of a changing culture, of a changing politics, of a changing nation, and of a changing world. But whichever way you look, my personal view is that the quintessential characteristics and the quintessential qualities of grand advocacy, in my personal opinion, do not and should not consist in just making more money and running from court to court and using, i.e., the Godfather connection and the networking connections and the face value in court. All of that happens today without a doubt. But that is not my conception of grand advocacy. I've always believed that at the end of the day, howsoever the law firms may disagree with me, howsoever many of my colleagues disagree with me, and I give this advice to all the young lawyers with whom I often have the chance to interact, at the end of the day, law is and must remain a profession. It cannot become business simplicity. And if we remember this distinction between law as a vocation, law as a profession, and law not being business simplicity, we will be able to set the right ethical standards to define grand advocacy. We know that the grand advocates were those who were inspiring role models. Before my time, the inspiring role models were people like Mahatma Gandhi, people like Jinnah, people like Jawaharlal Nehru, people like Motilal Nehru, people like Daftari. When I joined the profession, Daftari was fading out, and so was Mr. Sirwai. My connection with a few of the grand advocates whom I truly consider as grand, I would rate Mr. H.M. Sirwai. I would even rate Mr. Nani Palkhiwala. I would rate Mr. S.V. Gupte. And if you ask me today to rate advocates in terms of being grand in the sense of the values that are dear to me, I'll have a lot of time thinking. I'll have to spend a lot of time thinking. I do believe that at the end of the day, clients require results to be delivered. They expect results to be delivered. I know that the skyrocketing fees has become quite an eyesore, not only with the general public at large, but even within the legal fraternity. I think the hiatus between the fees that is commanded by some of our more fortunate colleagues and the others not so fortunate has in a way tended to make the profession oligopolistic, which it ought not to be. Today, I think we would be serving our purpose if we revisited our conception of what is grand or what should be considered grand. Grand advocacy in the context of law as a noble profession, using law as an instrument of change, using law for the protection of human rights, or like Edmund Burke said years ago, that it is a lawyer's function to sniff tyranny in every tainted breeze and then to fight against that tyranny. And more importantly now, the protection of human rights, which I think is one of the foremost challenges in a very, very troubled world. And that's the idea of globalization I would like to introduce. We are living in a very troubled world where you need advocacy of public causes, you need advocacy of justice in the broadest sense of the term, not justice according to the legal technicalities, but justice in terms of what people instinctively would begin to feel that this particular situation is just or this is not just. I see very, very little of that kind of advocacy through some of our grand advocates at this point of time. There are very few inspirational models, there are very few transformative lawyers, and that I think impoverishes the legal profession. It does not enhance its appeal. Monetary appeal, yes, More and more youngsters are taking to law. More and more of them are taking to corporate law, transactional law, because they feel there's more money. And I don't dispute their right to choose accordingly. That is legitimate. It's a legitimate aspiration to be well off, to make money, to take care of your needs. But in terms of the grandeur of the profession, the distinctions of grandeur must rest, have always rested, in the inclination, capacity, willingness, and ability of the grand lawyers, within inverted commas, to advance larger causes beyond the cause of the immediate brief. Of course, without doubt, the skill of a lawyer in court, his learning in court, the merit that he brings to bear to the brief in court, are all extremely valuable accomplishments of a lawyer. And I think all of those who have acquitted themselves on that measure need our applause and need our praise. I think one of the finest compliment that the judge can pay to a lawyer is that when a lawyer stands up and states a factual position, the judge will not even refer to the brief and accept the word as the final word. This was the tradition in which I grew up as a lawyer. This was the tradition which I was inspired to be inspired by. And if I'm permitted a very brief personal intervention, when I was designated senior counsel in 1986, I was only 33 years old, and that, I'm told, continues to be still the record. It has, there's never been somebody as young as that. And immediately after my designation, the rule in the Supreme Court was changed that lawyers with less than 20 years at the bar will not be able to apply for a senior's gown. And I applied when I had put in just 10 years and 3 months, and I was fortunate enough to have been given that designation by the Bhagwati Court. And we have a very, very rigorous system of designation of seniors. Certainly that was very rigorous at our time. Even if one judge disagreed, you could not be designated. But what I was told at that time, when I was designated by one of the former Chief Justices, was that if a lawyer learns never to misstate consciously a fact or consciously misquote a judgment or a precedent, that goes in the making of a very fine and a grand lawyer in times to come. You talked about the future. There's a clamor for law reform. There's a very strong voice now which says that this distinction is meaningless and it should be done away with. Perhaps it will be. I don't know. I can't look into the future. But for the moment, I do not see the appeal of the grand advocates waning or diminishing. With challenges that globalization has brought forward, with the kind of stakes that large corporate litigation involves, we now have the bilateral investment treaty disputes, which are very, very large stake litigations. Obviously and legitimately, the clients would want to have that person as the lawyer who doesn't even, whose face only doesn't count, but whose advocacy would also count, and who would be known to be the best projector of a cause. To that extent, I think senior lawyers known for their skills in advocacy will always retain their place. The tribunalization is not going to make any difference, because I now see many, many senior advocates regularly appearing before the tribunals, and indeed that is where the major disputes are going to be fought. And in fact, one of my juniors once asked, "Sir, what should I tell the instructing lawyers? Where will you appear? Where will you not appear?" I said, "I will appear in any court as long as the matter is a challenge to me, as long as I think the cause is worth my while to appear, and as long as there is a reasonable possibility of my bringing relief and succor to the litigant." So we have, I think, more or less done away with the distinction of where one will appear, where one will not appear. There used to be a time that some senior counsels will just appear in one particular court. They would say, "This is my court and I will not go outside of that court." Maybe there are some of our colleagues who still maintain that, but more and more of our lawyers are appearing everywhere, because the demands of the counsel is such. And I will give you this very, very personal example. I will, of course, not name the person concerned. A very a very distinguished lawyer, was once required to appear before a very important tribunal when I was the law minister, involving a very, very important policy challenge, which the government wanted this very distinguished lawyer to represent. And the lawyer was a bit reluctant, and he said, I cannot leave the Supreme Court at that point of time. But the government said, no, it's not a question of whether you would want to leave the court at that point of time or not, but this is an important case and you've got to defend it. So he did go there. So the point is that if the jurisdiction has passed on to the tribunals to decide critically important matters, the lawyers will need to follow the demands of the clients. Finally, the kind of fees that is being demanded by lawyers, at some point I believe it is unconscionable. But let me tell you a dilemma which I faced. I was in the Union Ministry from 2006 to 2009, and then there was a period of a year and a half, a little more, when I was not in the ministry before coming back to the ministry, and that was the time I went back to court. There was a matter that I had been arguing, it was an international arbitration matter, it had reached the Supreme Court and High Court several times. When I came back, that matter was still pending, and the instructing lawyers who had always instructed me came back to me and said, sir, the client now absolutely insists that now that you are free, you should argue this case. And I said, fine, I'll argue the case. I argued the case, and then the time came to for me to raise my invoice. And I raised my normal invoice, which was not less, but which was not horrendously high. And I sent it to the instructing lawyers, and the instructing lawyers came back to me and said, sir, we are very sorry, but we just cannot process this bill. So I said, have I charged too much? He said, no, you've charged too little. So I said, but then what can be the problem? He said, the problem will be ours, because when you were not at the bar, we had engaged so-and-so, who is way junior to you in standing. We had got his fees approved, and accordingly our fees was approved likewise. And now when the client will see your bill, they will think that we have taken the client for a ride. So you are going to create a huge amount of problem for us, sir. We beg you to raise this bill. So I had to raise that bill, and of course I was paid. But I do believe that the fees have become absolutely unconscionable, and the tragedy is that within our peer group we cannot charge less, because if you start charging less, they will say, well, he's no good lawyer because he's not being paid that kind of money. So it's a kind of a difficult decision making in terms of personal matters about fees. I would be perfectly happy if there was some kind of a way where we could regulate the fees reasonably. Of course, the expectations are too high, people have got used to certain kind of fees. Gone are the days when 1,680 rupees was the fees for an SLP. I remember when I was designated senior counsel, the fees was 1,680, and if you were a respondent and if you were just appearing after notice matter, it was 1,040. It is a very interesting incident which I will recount, and then I'll sit down and take my seat. There was a very distinguished former Chief Justice of India who was a tax lawyer. He was a regular at the Supreme Court, and he was known to be amongst the first three choices in a tax brief. A young lawyer went up to him and said, sir, I would like you to appear tomorrow in this matter. He said, very well, fine, I will appear. And he said, sir, should I mark the regular fees, 1,680? He said, yes. And then on reflection, the senior said, well, is it a heavy matter? He said, well, sir, it's a normal matter, but for you it shouldn't be difficult. Of course, there are a couple of pages which you'll have to read. And on some reflection, the senior said, okay, then please add the reading fee to the fees of 1,680. So the junior lawyer thought a while. He moved forward and turned back. He says, sir, I'll tell you what. You please come without reading. So he didn't even agree to a modest reading fee. He says, sir, you come without reading. So he had to be content with that fee. So there we are. Times have changed. Expectations have changed. But my expectation of brand advocates is that they bring to bear their professional and moral superiority, if they have one, in aid of larger causes, in aid of high standards of ethics in the profession, in aid of intellectual and professional integrity, and also in aid of making law as a potent instrument of social, economic, and political change. Thank you very much.
Please, Mr. Kumar has to leave, so please give him another round. We know we're quite aware this is a very, very busy time, particularly for the grandness of grand advocates, so thank you very much. And you're all right, Margaret, I'm looking down there. And Shahana, if you don't mind, could you be Mr. Luther at the end of there? Because I fear Raji won't be able to join us. So, Margaret, please.
Thank you to the program on the legal profession for having me here. It's been an honor. And, I kind of find it ironic that a person who was born and bred in Mumbai is coming to Delhi and lecturing on how to influence India's policy frameworks. So, how did a person who was born and bred in Mumbai even end up being here? And I think for that reason alone, I would just like to talk a bit about the motivation for this paper before we delve into the findings. And like Professor Wilkins mentioned, before I went to Harvard Law School on a research fellowship, I was at a corporate law firm doing regular cross-border transactions. As everybody knows, India is partially capital account convertible, which means that there is a complex administrative system of rules which govern inflow and outflow of foreign exchange. As the complexity of cross-border transactions grew, we increasingly found ourselves propositioning the central bank, the Ministry of Finance, on how they should think about different complex structures and how they should regulate different complex structures. And we found that they were quite open to such inputs. And this led me to wonder that if this is the influence that we are having on such a narrow part of lawmaking, what is the aggregate influence of the modern corporate legal sector on lawmaking processes in India? And is there any influence in the first place? Can we quantify it? If we cannot quantify it, can we get anecdata? When I say anecdata, I mean anecdotes which aggregate to data. So that is the kind of exercise that I proposed to Professor Wilkins in 2012, and I must say that it was very generous and I dare say brave of him to allow me to pursue this thought process and take it up as a research project. So what did we find? I think it's been mentioned throughout that Indian lawyers have always had a very prominent role in political life in India. To just put some numbers to this, the first parliament of India had 36% MPs were lawyers. That was the largest professional group in India's first parliament. Now to think of it, 7% of MPs in the 16th Lok Sabha are lawyers. So definitely that has reduced. In any case, that role is not played by what we consider as the modern corporate legal profession. Those lawyers are grand advocates, typically, or people who've been in the litigation field. So the way to think about this is, if modern corporate legal profession is not playing a role on the floor of the house, where is it playing a role in the lawmaking process? And this takes me back to Mark Galanter's typology of the American legal profession. He says that the American legal profession, can be classified into two types of lawyers. There's the strategic lawyer, who basically interfaces with the client constantly, who optimizes the regulatory environment and plans the client's operations such that he gets the maximum benefit of the regulatory environment, who appears for the client before judicial, quasi-judicial, executive, and legislative forums. So we have the classic go-to Washington lawyer, who is known for his skills of engaging with the Senate, with the Congress, etc. And American law firms also position themselves that way. So if I can read some marketing materials, so if you have the Skadden apps, attorneys at Skadden have long-standing relationships partnerships with representatives from the US government. Jones Day successfully lobbied both the Australian and Chinese governments, resulting in the Chinese security forces conducting raids. Sidley Austin, dedicated to ensuring that our clients' positions are well understood by key members of the Congress. This is the marketing material of the classic strategic American lawyer. We see this also in the UK. We see marketing material which says, law firms are shaping law and policy as it evolves, public policy practice area comprising of legislative drafting, political intelligence and monitoring. And just to go back to Mark Galanta, the second type of lawyer is the service type of lawyer, the classic Indian lawyer, who focuses on existing litigation, existing set of facts, existing fructified claims. And Mark Galanta in 1989 claimed that the Indian lawyers, bulk of the Indian legal profession, really fell in this category. We are in 2017 today, and my submission is that we have increasingly moved towards a strategic type of lawyering in India. One part of it is, of course, working with corporations and clients round the clock to plan their operations. The second part of it is appearing before legislative bodies, dealing with administrative bodies so that clients' interests are well taken care of even there. And why do I say that? I believe there are three characteristics in the US which has actually made strategic lawyering possible. The first is the rise of the administrative state, where lawmaking is decentralized from the government and the Congress into a varied set of regulatory and administrative bodies. The second is the practice of public consultation in the lawmaking process. And when I say lawmaking, I also mean subordinate legislation making. And the third is the movement of persons between the government and law firms in the US. Just yesterday, I was talking to an economist who's ex-World Bank now. He was with the World Bank for about 15 years. And he tells me, I don't know if this is true, he tells me that the 4,000 topmost positions in the US administration are actually held by people who are not part of the regular civil services examination. They're held by people who will cease to be a part of the US government the moment the political administration changes. So if you have Democrats in power, it's the people who are aligned with democratic philosophy, and they are occupying the senior-most positions in the administration and vice versa. And when they leave government, they typically go back to their private sector, or they start their own think tanks or consultancy services. Brookings Institution, I believe, was in fact founded that way. So my submission is that we are slowly seeing these features in India. And why do I say that? The first is rise of the administrative state in India. Since 1992, we have about 15 federal regulators in India regulating across different kinds of sectors, right? From financial sector to infrastructure to warehousing, you name it, you have a federal regulator. This does not, I'm not even mentioning the state level regulators like electricity regulators. So we clearly have an administrative state coming up. There is no Administrative Procedure Act kind of law in India which mandates consultation with the public before subordinate legislation is enacted. But we increasingly see regulatory governance being embedded in the DNA of these regulators. So for example, in a research paper that I wrote in 2016, we found that in the 2 years from 2014 to 2016, 57% of the subordinate legislation issued by the telecom regulator underwent some sort of a public consultation process. About 41% issued by the airport economic regulator, the regulator which is in charge of regulating tariffs at airports, underwent some sort of public consultation process. India's newest regulator, the Insolvency and Bankruptcy Board of India, has a tab on its website which allows you to submit constant rolling comments to the regulator on the bankruptcy laws. Also, as the administrative state comes into existence, these regulators need specialized skills. If you see these regulators today, the way they are composed, they're not composed of people who have passed the civil services examination. They're composed of people who are not typically from the IAS background, except the topmost cadre, of course. So the generalist knowledge no longer works. So we have the administrative state in India. So the first condition that I mentioned in the US is kind of satisfied. how are Indian law firms responding to this? And what we see is that if you see the positioning of Indian law firms, see the marketing material. This is the marketing material from 2014. Maybe it's a bit outdated, but I'm sure we can find parallels even today. For example, Amarchand Mangaldas' marketing material in 2014, complex negotiations with the executive and legislative branches of the government. JSA's marketing material in 2014, actively involved in policy issues affecting PE and VC industry on a national level, including legislative and regulatory matters. Dua Associates, which was a law firm, has actually set up a sister firm which has significant experience in developing effective strategies and presentations to government. So you see the positioning of Indian law firms has also gradually started moving towards the strategic lawyer that Mark Galanter spoke about. In the course of our interviews, when we actually interviewed law firm lawyers in 2014, while they have this marketing material up on their websites, etc., they were at the same time, arguably justifiably so, apprehensive of being perceived as lobbyists. So they insisted that when they petitioned the government or the legislature or a regulatory body to do something, it's in the interest of the industry and not in the interest of a specific client. So this is a self-perception of the modern legal profession about itself. They insisted that this was not a revenue center, but an ancillary activity which they did just so that they could help out their clients. And 50% of them believed that the demand for such representation would increase, but there was no commitment to build focus capacity. So these are our findings from interviews. And the recruitment practices of Indian law firms have also seen significant changes. We regularly see ex-officers of regulatory bodies, including the central bank, being hired after retirement by Indian law firms. We see members of the revenue services being hired by Indian law firms. So the third condition that I mentioned about the revolving door in the US, we are already seeing some trends in India. So what are the touch points with the legislative process for the modern Indian legal profession? Like I mentioned, on the legislative house, there's not much scope because the modern Indian legal profession hardly is a part of either house of parliament. Before parliamentary committees, we find that most of their submissions are on behalf of business or industry associations. In the last 4 or 5 years, a unique opportunity has emerged in the form of drafting commissions which are set up, particularly in the financial sector space. So for example, I mean the classic example that most people over here will be familiar will be the Bankruptcy Law Reforms Commission that was set up before drafting the Bankruptcy Law of India. We had full service law firms who were servicing this commission. There were law firms who were extensively consulted in the drafting of the law. Another example that I can think of is the Financial Sector Legislative Reforms Commission, which made structural reforms in the way our central bank works, in the way we decide rate cuts, etc. They dealt extensively with lawyers. And an ongoing bill, which is the resolution of financial firms, that team is also serviced by lawyers. Lawyers not only help in drafting the primary law, we have seen their involvement in implementation of the primary law, so extensively involved in drafting of subordinate legislation. They are also involved in capacity building of regulators. I believe some law firms were involved in training people who are currently employed by the FSSAI. Lawyers also wrote a report which basically set up the new bankruptcy regulator, the organization design, the hiring practices, the bylaws to be followed, etc. But it's not only the lawyers, it's not only the law firms which really do this, and over the last 1 year, we've seen a lot of change, and we've seen many new players in this space. So we have players with interdisciplinary skill sets who actually assist the government in this job. So there is, I also work with a group which has a bunch of economists, lawyers, people with experience in public administration. Our only job is to provide research and policy support and foster a research culture when you design policy for the government. A lot of them are not concentrated in Delhi. As you know, Bangalore has a few think tanks which basically work on internet policy. The legal teams of government and regulators are expanding, so they too have a role there. And there are university house research centers such as NLU Delhi, which influence the thinking of the government in different areas. And just quickly, 3 takeaways from this research project are that the demand for expertise-oriented representation before the administration is going to increase. The demand for expertise-oriented support for the administration, where you're actually supporting, not representing a client, but supporting the administration to design policy in complex areas is going to increase. How does one respond to these demands? One way of doing is to invest in medium to long-term research. I think a couple of law firms are already doing that, where they are fostering a conscious research-oriented culture. The second way of doing it is to collaborate with multidisciplinary researchers. A policy cannot only be made by people having expertise in law. You need people having expertise in economics, public administration, and the whole works. And finally, I would like to say we need to learn from the econs, because they have killed it at this. Thank you.
Thank you. So Bharat, would you like to speak from there or there? Here. Okay.
If I am permitted to speak from both the papers quickly.
Yes, please, please. And then I know you have Bharat also has a plate, so
Yeah,
please,
but I'll be. Very good afternoon to all of you. I'll go sequentially. I'll first comment briefly on the Grand Advocates paper written by Nick. First of all, I want to say that the facts which you have stated are pertaining to, I saw most of the interviews around 2011-12, and the things have significantly worsened, if I can say, in 2017. The hierarchy has become more steeper. First of all, at the outset, I must say that these grand advocates which are referred to, in my experience and all my life I've been consulting them, are some of the finest intellectuals I have met. They're outstanding men of exceptional intelligence and advocacy skills. Exceptional, I would say. They're all fantastic. You go a 700-page brief and within few minutes they chuck out 3, 4, 5 points. On a Monday and Friday, Supreme Court SLP admission days, within 3 minutes they can get you an interim relief in a very heavy matter. So exceptional men. But I tell you where my concerns are and where the things are currently. First of all, Nick, the figures of fees which you quoted are fairly ancient. 2017, it has gone up at least 3 times in some cases, sometimes even more, at least. And I have found, and many of my colleagues in the in-house profession has found, that in Indian law arbitrations, I find it is cost effective to consult QCs from London, and I have engaged them, then engaging our grand advocates, because it turns out to be far more prohibitively expensive. The second worrying part, as a consumer of legal service, I can tell you that despite such high fees and commitment, their appearance in the court when your matter is called out is not guaranteed. As a result, the client is forced to engage multiple of them with a phenomenal resultant increase in their fees, because you don't know finally when the matter is called out in the Supreme Court or High Court who is going to be there to argue the matter. And you have to do a multiple briefing sessions with each one of them individually, because they will not meet together. And so obviously you have a multiple grand advocates in any very high stake matter, which disproportionately increases the cost of litigation and cost of doing business in India. And frankly, as an in-house lawyer or general counsel, I had extreme difficulty in convincing my management why we are incurring such a high litigation cost, and why do we need so many lawyers in the matter. But they don't realize the practical difficulties that in Supreme Court they take up so many matters that when your matter is called out, and I don't know, I have still not figured out how they decide which matter they will appear and which client they will ditch. So that is another major issue which is there, which I think need to be kind of, every one of you must have experienced it. The other issue which is there is as very rightly observed, many of them are connected with politics. Many of them you see regularly at 9 p.m. television channels on every national issue they have views. And along with the conferences with the clients, they also appear for television. Cameras are waiting in their offices all the time. And so you have suddenly they give an interview to NDTV and then again they come back and they are very quick in again coming back to the matter. There are other aspects of this which because of paucity of time I won't be told. What I can say is that this practice which was there in the pre-independence era has continued, has thrived, and has continued even post-1991, and is becoming even more and more acute. And now this concept of super seniors have come. We call senior counsel and super senior, who are not 40, 50, but just 7 or 8 of them. And exceptionally high fees, and you have to, but you know what has happened is that unfortunately the way the Indian judicial system is designed, you know, your US Supreme Court deals with 55 to 60 matters in a year. Here, before every bench of the Supreme Court, we have 200 matters on Monday and 200 matters or even perhaps more. And they have such a little time that the judge feels very convinced if a very senior super guy comes who is regularly appearing in the matter, seeks certain relief, and they don't give you more than 2 to 3 minutes. A very heavy matter, they have 3 minutes to argue. Not more than 3 minutes. And that exactly is the case with most Mondays and Fridays I'm talking about. And some of the lawyers don't like even coming on final hearing matters because they will involve study of law and facts much more deeply. So their entire career they've worked on interim orders. And Indian judiciary works on interim orders. Many of you know, once you got an interim order, you almost won the matter because effectively the final hearing it will come after 10 years where the matter may have lost the relevance. So the reality, and again very rightly pointed out by Mr. Aswin Kumar also, that the fear that with the tribunalization, whether the supremacy of grand advocates will diminish, certainly not. Many of them had privately told me that this National Company Law Tribunal and Competition Tribunal, they are not going to appear. Each and every of them are coming before all the tribunals now because, and can I tell you something, National Company Law Appellate Tribunal has become the most powerful court in the country after Supreme Court. If you see every matter relating to Companies Act, insolvency, competition, it goes to the National Company Law Appellate Tribunal in Delhi. That one bench is the most powerful bench in the country today. So effectively most of the super seniors do appear before these tribunals and they do have a very strong presence there also. So now we have a very serious situation that first of all, we were worried about whether he is available, which courtroom is available. Now we have to worry about which court is available because he may not be in Supreme Court, he may be in Tribunal or in Delhi High Court. So we have this practice, very unique for India. As in-house lawyers, I told you that I have virtually on Indian law matters, I have started consulting QCs now. Learned English because our laws are similar, so they are very cost effective and they appear when they guarantee that they will appear. They can't appear in Indian courts, but they can certainly appear before the arbitrators. And I have seen arbitrators happening in this very hotel in Delhi. English QCs fly down from London, and they are less expensive than our grand advocates. So that is a client's perspective of what we go through. And I don't know whether there is any solution in sight in the near future, because the practice continues, and if you come 3 years later, the fee rates would be again different. But that the reality is there, that this is there, and today Indian judiciary, the way the entire judicial system works, we need them. And there is again, I would like to mention again, at the cost of repetition, they are men of exceptional abilities. They have phenomenal memory, but most importantly, they have fantastic advocacy skills. Then they can get you orders which you want. And I think to some extent, we in-house lawyers also need to share some blame because we also want to pass on some risk. So if you have engaged a grand advocate, the chances of if the matter goes wrong, we don't have any internal, we can say we had hired the best of the lawyer, but we couldn't win. Now turning to Bhargavi's paper, I must say very well-researched paper. Bhargavi, full marks to you. I just want to, it's a very well-researched paper. I just want to say a couple of things. Because of the fact that there is some negative connotation in India with regard to the use of the word lobbying, what I find most Indian law firms now call it as we have a very strong regulatory practice. It's not even called advocacy practice, it's called regulatory practice. If you see, you go to and meet the senior partners of the law firm. He said, we have very strong regulatory practice. We have a former deputy governor of RBI working with us. We have former chairman of the Competition Commission working with us. We have former executive director of SEBI working with us. So it's a regulatory practice. Well, they have been playing a very critical role, as I can tell you from names. Recently, we had a Uday Kotak committee report on revising the corporate governance norms in Indian listed companies. And Zia Modi and Cyril Sroff were very important members of this committee, and the chairman of the SEBI had to admit that they drafted the report. So effectively, that's there. Insolvency and Bankruptcy Code, Mr. Behram Vakil of SZB was very critically involved, and there's nothing wrong in it, because they bring a lot of technical expertise which is needed. I was very intimately involved in revising India's Companies Act 2013, where the bill is pending in Rajya Sabha, just now likely to be taken up on Monday. So I don't see, in fact, can I tell you something? I find bureaucrats and regulators are reaching out to the law firms and the lawyers and in-house lawyers to seek their practical expertise, because unlike in the West, where there is a seamless movement from government to the private jobs, in India that's not happening. In India that's not happening because of the way the Indian bureaucracy is structured and the way the pay differences are there between private sector and public sector. So effectively, many of the public sector people realize that this is a very important commercial legislation where we don't have a practical perspective. So in fact, they reach out and ask comments from these lawyers whether they will be willing to provide how the things. In fact, I believe the most important SEBI regulations, QIB regulations, was drafted in a law firm's office. And nothing wrong with it, because effectively they bring a lot of value to the table. My only concern is that what is happening now is that as Bhargavi mentioned, that the regulations and regulators are increasing by the day. My biggest concern is that the quality of delegated legislation which we have in India leaves much to be desired. Many a times I find that the delegated legislation goes directly against the principal statute, but nobody bothers because it's suiting the industry. The delegated legislation is changed so frequently, and the problem which we find is that the one essential tenet of a good legal system is that continuity and stability, which is lacking in India. You buy any book on SEBI rules, SEBI regulations, within 1 month it is out of date. Because every week SEBI comes out with so many notifications, and they believe, because somebody has represented this rule is not working out for us, change it. So effectively, I find that both Reserve Bank of India manual and SEBI manual, I don't purchase their books at all, because you have to go to the website. Every week the law is changing. And if you are out of touch with these regulations for 3 months, I can say you are completely out of date. That is the way the legal practices in India has emerged. Well, law firms have been playing a very important role with regard to their shaping up, and they will continue to play a bigger role, in my opinion. What I find is that in-house lawyers and general counsels have also started playing a very important role. For example, I almost have a monthly meeting with most of the important regulators every month, and give them a perspective of which regulation is hurting us, which regulation is beneficial, where the drafting is deficient, which drafting needs to be revised. And I see nothing wrong with it. I think that is the only way they can get the feedback, and that is the only way. And eventually I suppose that at some stage, the word lobbying, which became very unpopular, particularly in 2010 because of one scam, would come out of the negative connotation, and people will officially, as and when the Indian lawyers are officially allowed to advertise, they may say that we do advocacy role. Lobbying will still not be accepted in India for whatever reasons, but advocacy will certainly be accepted. As Bhargavi rightly pointed out, some of the law firms' publicity material, I wouldn't call it marketing material because they don't like to use the word marketing. Publicity material does indicate that they have a very strong practice, but I find that the right nomenclature they are using is that very strong regulatory practice. So both the papers were outstanding, David, and I would say that both the researchers have done a phenomenal job, particularly Nick, who is not familiar with, who is an outsider to Indian legal system, has written about senior advocates and grant advocates. Exactly any Indian person would have written a fantastic research. And everything what you have said in your paper is absolutely true. Only thing is that it needs to be updated now because the things have changed. The problem has become more aggravated and acute. While it is whether the grant advocate system is good or bad for the country, I wouldn't comment, but certainly it's bad for the consumers of the legal services. Thank you.
Thank you, Bharat. Thank you.
So, Shahana, this really isn't fair, but I thought the reason why I asked Shahana to step in because Rajeev might not make it is she has such a unique perspective. She's practiced in the UK and the US and here in India. She's been both in law firms and in in-house counsel positions, now more than one. So she's got a really unique perspective to think about both of these issues, and any brief comments you have, Shahana, would be fantastic. Plus, she's one of the smartest people I know. So.
Thank you, David. And it's great to be, I want to take a photograph with just this. It's like stepping into Rajeev Luther's shoes is very hard, and I'm actually.
And those are big shoes.
And those are big shoes
yeah,
to fill.
that's a joke.
Really happy to be doing that. But just, I think we've had such a great panel. I just have some concluding remarks almost. But just to jump off on the grand advocates, I agree with everything you've written and what Bharat said actually, that there is this focus on a few grand advocates which are the superstars of our profession. And in a way, it's become actually interestingly, what has happened with law students, and I talk to them all the time, is everyone now wants to be a Harish Salve, and everyone wants to be a Mukul Rohtgi. And so there's this focus on these stars, and so much curiosity and gossip about how much money they make and what cars they drive. And so it's almost like, the US when people see Suits and Ali McBeal and want to go to corporate law firms. So there is kind of this pyramid structure and a very few people making a lot of money, but a lot of focus on them. And another thing I want to sort of add to what Bharat was saying, that, this whole idea of having for corporates to actually have a lot of lawyers that for any big matter. What is unusual in India to me is that one of the strategies that is used here is one of preemptiveness. So what they will do is immediately if there's a big matter coming up, go put all the big guns on your team on retainers. So it's almost to prohibit the other party from actually hiring them. And these are also long-term strategies where big names are put on retainer basis for years and years. So, that's an interest, it's from a
absolutely
strategic
true.
position.
I have done it myself, so I can't. I can't say no.
I didn't name it, but yes. But so I think that's a strategy that's used, which you don't see in the US and the UK so much. People are pretty, faithful to their law firms and their lawyers. They're usually tied with one or two law firms, and they stay faithful to them. So, on the brand advocates, and I agree with the fees. I think it creates this perversity in the market where people are just looking at the highest paid people, but not looking at all the people in 30,000 and people who are really struggling at the lower ends, right? So you have this in the market in terms of fees. I think we only focus on the highest paid people. And coming to your paper, Bhargavi, I thought that was really an interesting and, and it's an area of interest for me because I've also always been very interested in public policy. And one thing in India, which I think is again very new, we've never been taught public policy. So the Jindal school is really the first of its kind. You never had this sharing because it comes from the British tradition of purist subjects. You only taught economics or law or political science, and you're not taught, so the framework for thinking about public policy in a way doesn't exist. So this is a very new development, and I think one of the pioneers of that actually has been a Harvard Kennedy School graduate. I think I want to mention PRS, C.V. Madhukar, who set up PRS, which is Parliamentary Research Service, which really looks at how legislation can impact different groups and actually advises the legislator. So it's, looking at it from another aspect, and you have lawyers and economists and multidisciplinary, this is something he started, but more recently there's Vidhi Center for Legal Policy, which I think is again fascinating, that you have a 28-year-old lawyer comes down from Oxford National Law School who sets up a group of lawyers who are actually now drafting the Data Protection Act, Pesticides Bill, new media legislation for the Delhi High Court. So, and this is interesting because these are not people from law firms but who have law firm experience, but they're focusing on drafting policy from a completely objective third-party view. So they
very passionate.
and very passionate. So again, I think these kind of thoughts that are coming in are very, very good. And in terms of the differences, I think in the US, I mean, I worked at Sullivan and Cromwell, and the biggest thing for that law firm was that they drafted the Securities Act of 1933. And till this date, you know, that is their biggest selling point. So this every law firm in the US, if you're associated with one of their big legislative initiatives, it becomes your calling card forever and ever, right? And I think Indian law firms are getting there, as Bharat rightly pointed out. For the Quota Committee, you had Cyril, you had, you know, bankruptcies, yeah, and also very publicly so. I mean, they held, you know, one thing is doing it in the background and sort of giving views, but I think now law firms are also realizing they want to be at the forefront, that it's good for them to come out and take a neutral view, because they're advising a lot of different clients and taking a more intellectual approach as well. So they're also looking at it from the legal profession, and then getting views of not only their clients, but sort of going around having seminars on a more education basis, which I think is a very, very good trend. So you see that, and I think Bhargavi is absolutely right, that it's also these new regulatory agencies. So you see CCI is a great example where you have now the importance of economics and law in public policy, because earlier it was just, you know, you had the bureaucrats, but now the specialized expertise you need in CCI, and you have people who work with corporate law firms, economists, now advising CCI, now they come out and then they join law firms and in-house again. So you have again that revolving door, I think, is becoming more and more robust. So I think all these trends are very nascent. I think they're developing, and I think with law schools also giving people a chance and focusing on them, I think a lot more people are going to, who are passionate about public policy, also have areas where or like law firms where they can go join, because that's what they're interested in. Earlier, I don't think that opportunity even existed. If you were interested in public policy, there was nothing you could do. You couldn't go, and now you even have parliamentarians hiring interns, having law clerks, having lawyers coming and help them understand legislation. So I think there is a lot more that is going on in terms of, you know, exchange of knowledge between the law firms, between the government, regulatory agencies, and law professors as well. I think professors are also realizing that that is something they can contribute by writing research articles, by interacting with the regulators, getting a sense of where the law should go as well. So this whole shift in India, I think, from the positive to the normative, what should be, I think there is a greater focus, which in the US system is, of course, the ultimate strategic. It's not strategic, it's really looking at law from where the law should be rather than where it is, and how do you take that the law as it's in its most benevolent role of as an agent of social change. How do you envision that? And I think that process is starting now in India, I think, at different levels. So very excited about that.
So thank you, Shahana. You can see why I asked her to sit in. It's been a very long day, but we have time for a few questions. I think we should collect them again as we did before. Please be concise in what you're doing, and then I'll let the panelists respond. And Bharat's got to catch a flight, so I'm very mindful of his time. Brian, and there's somebody in the back here. There's some young man here. Yes, please. We'll start there, and then you've got here. Keep looking. So please stand up, say who you are, and just a short question, and then we'll collect a few, and then we'll let the panelists respond. No, we've got one back here first. Thanks.
Hi, I'm Kaustav Saha. I'm an associate at Keystone.
It has really been an astounding 10 days for me and for all the members of my team and everyone who participated in this project. First and foremost at the moment, please just help me to thank these amazing panelists who were here on what really is the critical topic, right? Which is, what is the role of the lawyers we study in the development of the Indian state? I also want to thank all of the people who made this possible, including all of our sponsors you see here, including Luther and Shardul Amarchan and SNR and our travel partners, Air Canada, and our media partners who are still here filming this. This is all going up on the web at some point. Hopefully it will be able to spark a dialogue, not just among all of you who were kind enough to spend your Saturday here or Friday evening yesterday or in Mumbai, but at a much wider level. And that's because this conversation needs to go on. And it's at a critical point in time. And Shahana, I asked you at such short notice to fill in for the legend because I knew that you would point us in the right direction. And what did you say? You said the critical question is not just what the law is, but what the law should be. And the premise of this book is to answer that question, you have to ask the question, what should the legal profession be? One thing that when we go to law school, we focus on the laws, and we focus even on the judges, but we don't focus on the lawyers who are the ones who argue the cases, who brief the matters, who whisper in the ears, who advise the clients, who are such an integral part of what the law will be. What the law will be largely, not completely, but importantly determined by what lawyers do, and not just when they're standing before judges in courtrooms or standing on the courthouse steps and declaring, but what they're saying to their clients in their offices, or how they conceive of what the law is and what the law should be and what their role in the process should be. Our premise in this project is that to understand that, what the legal profession should be, you first have to start with what the legal profession is. You first have to actually take what lawyers do as a serious source of a subject of inquiry, as serious as what the corporation law should be or the criminal law should be or what the Constitution even should be. Because if you don't understand what lawyers are actually doing, it's hard to know whether they're doing what they should be doing or whether there are other things that they should be doing or what the ethics or the ethos of being a lawyer should be. We heard a lot about that, even on this very panel. Mr. Swami Kumar spoke very eloquently about that and his vision of that. We've heard law students speak of this. We heard Raj Kumar speak of that about the vision of his law school. We've heard many people both praising and critical of what the vision of the lawyers should be. My argument and the argument in this book and what we've tried to do here is to give you a window into looking at what the legal profession is here in India today and how it got to be where it is in India today in this critical period, which again I'm calling India's development 1.0 since 1991. But of course, the real question all of you want to know is, well, what should it be in the next phase of India's development? 2.0, 3.0. That's what's of interest to everyone in this room, but particularly of interest to the brilliant young people who have been here today. And I just can't thank all of you enough, both the volunteers, but also the law students, some of you who traveled from great distances to come be here today, to give up some of your precious time to try to learn about your future. We did this book for many reasons. We hoped it would produce many things. We hoped, first of all, just to produce a book, which, as James and others said, some people were doubtful whether that might ever happen. It took a long time. We hoped to produce conferences and dialogue, meetings like this in which we brought important people together. And I'm proud to say that we have done that, and this has been an amazing example. But mostly, we want to play some small role in producing the new lawyers of tomorrow, who will take India forward and through India the world. Because as we've heard also many times, India it's always been a critical part of the world. Your history goes back further than almost any other. But in this new world of tomorrow, there is no question that what happens here in India is going to matter greatly to what happens in the world. And what happens in India will matter greatly about how India thinks about the rule of law and the future of law, which will then be determined by what Indian lawyers think is about their role. This has been an incredible collaborative effort. Many of the authors of the amazing chapters in this book are still here. Many of them couldn't be, but each of them, I would argue, is a patriot to India because they've tried their best to try to understand the dynamics of where India is and where the legal profession is. And I guess at the risk of imposing too much, I think that applies to those of us who are not Indian citizens either. We hope to be patriots of Indians and to believe in India and to believe in this great country. None of this would have been possible without my incredible team who's, again, standing in the back, watching the time, making sure we've got everything in a row. So one more time, please thank Catherine Flynn, Brian Fong, and Margaret Ivins. Sorry, Margaret, you're a part of the team now, whether you like it or not. I'll just end here. We always said this was the first step in a conversation. The conversation we've had in this fortnight since we've been here has been incredibly rich, but it's just the beginning. And quite frankly, that conversation is mostly going to have to be carried forward by all of you in this room. We hope that this book provides at least a kind of foundation for thinking about it, but we hope also that you will challenge it, that you will criticize it, that you will move it forward in your own way. And all we ask is that you let us see the results. And if that happens, I am quite confident that India's best days are ahead. Thank you for all your time and attention. Thank you.